lot, and it is a state-run authority park. And the upper end is CNN and food court and going to the Phillips Arena, and people traveling over to the World Congress Center. And the problem was that the city police were not able, they're selling drugs on the corner like where they sell the tickets too, they're selling drugs too, and they could not have authority to be able to make arrests there.
All right, thank you very much. Are there any questions? Yes. I'll have a motion. All right, we have a motion proposed. Are there any questions for the senator regarding this fine piece of legislation? I don't see any questions. I don't see any questions. Representative Levitas.
Mr. Chairman, I move that do pass on LC 380639S SCS.
Thank you very much. Is there a second? 2 seconds. All right. Is there any further discussion? Seeing no further discussion, all those in favor of giving a do pass recommendation, raise your right hand. Those opposed, wait a minute. So raise your right hand if you're in favor again.
I like that.
Madam Chairman, you have set a record.
I know. I've been before this committee.
I want you to take a good look at the faces of this table. If you see any of them in the next few days, you need to be very kind to them.
I'll look for you in Rules Committee. Thank you.
All right.
You're a former member of the House.
I am a former member, yes, sir.
That's the only reason you got favored.
Hey, y'all remember that next time?
Next bill we're going to take up is SB 16. This is an Animal Fighting Act.
Substitute,
Mr. Williams is here to present it.
Thank you, Mr. Chairman. I bring Senate Bill 16, substitute Senate Bill 16, which was brought to me by some local sportsmen in my area that are having a problem with people removing the tracking collars from their sporting dogs. These are very expensive pieces of equipment. Not to mention the result is loss of a very expensive trained sporting dog. And I think this is important piece of legislation. We're substituting the Senate bill, dogfighting bill, because of the going with House Bill 301 is the bill that both chambers seem to be pleased with and one's moving forward. So.
All right. Are there any questions for Representative Williams about this fine piece of legislation? We do have somebody signed up to speak to it.
No questions, Mr. Chairman.
Is it Jenny or Lenny? I can't read your right. Jenny Hodges. Miss Hodges, do you want to speak to this bill?
I do, and actually I wanted to speak to the language, not the substitute you just now mentioned.
All right, well, come on up here if you want to talk to it.
Great, thank you.
If you'll just stay where you are, Mr. Williams, she can sit there next to you.
Pretty close.
Hey.
How you doing?
Good, how are you?
I'm sorry. Yes, ma'am. Would you
Yes.
identify yourself and give us your comments on the bill, please?
Yes, my name is Jenny Hodges. I lobby on behalf of myself. I'm commenting in regard to the original language, I guess, of the bill that Senator Rogers had submitted concerning dog fighting and the ability of people within the state to train dogs to kill. And
It's not on here. This is a substitute. Can she get a copy
Yeah.
of the substitute bill?
this one I don't care to comment on necessarily.
Okay.
Well, this is
We're just dealing with the substitute.
Oh, excuse me.
Any further comments?
No, you're fine.
Never mind.
Jeremy, you're sit back down.
Well, we appreciate you coming anyway. Thank you very much.
Will there be no discussion of the other bill?
There will not be today.
Okay, thank you.
And is it Reggie Dockey?
but I support the bill and the amendment. Everything's back.
You're with who, Mr. Dockey? All right. Okay. Did Carolyn Denise, Humane Association of Georgia.
Yes, sir. I just wanted to point out that because electronics are getting so much cheaper, it's not going to just be dogs. Everybody's going to have little GPUs or whatever on their car, so it's going to be a much bigger issue.
Okay. Thank you. All right. Did somebody wanted to be recognized for a motion? Mr. Bearden.
That's the substitute to Senate Bill 16, LC 293370S, do pass.
All right. There's been a motion. All right. All right. You're just trying to stress me out, aren't you?
No, sir.
substitute motion?
Yeah, I've got a substitute to Senate Bill 16. I'd like to pass out and move that we adopt substitute to Senate Bill 16 LC 219910S. These are the original ones and twos.
Put on your seatbelt. All right. You want to explain your proposed substitute motion?
I would be happy to, Mr. Chairman. This proposed substitute to Senate Bill 16, since we heard on the dogfighting bill on House Bill 301 originally that the main intent of the author of that bill was to protect innocent human life from the dogs that are trained to fight that get loose and kill defenseless innocent humans. I'm proposing this substitute to Senate Bill 16, which will prohibit prenatal murder. And the first roughly 4 pages gives us the legal basis for being able to prohibit such an offense. It defines terms, declares that prenatal murder is contrary to what we are about as a state, and makes it illegal, and then punishes it, and then repeals several pages. Basically, the remainder of pages 4 through 7 repeals existing code sections where prenatal murder has been permitted, regulated, or otherwise referenced. And that's basically it, Mr. Chairman.
I think I recognize Mr. Levitas for a parliamentary inquiry.
Mr. Chairman, I would inquire as to whether the substitute is germane to the bill for which it is offered.
The chair has considered that matter and is ruling that the substitute is not germane to the issue before us. Yes, sir.
I'd like to appeal the ruling of the chair.
And who are you going to appeal it to?
To you, the chair.
All right. That's going to be the ruling of the chair. Thank you very much.
I'd like a vote on that, Mr. Chairman.
Well, I don't know that there is a requirement for a vote. If you can show me some rule that requires that, I'll be glad to reconsider the matter. But for right now,
I don't have the rule book in front of me, but I do know that if House rules apply, you can appeal the ruling of the chair.
okay.
And that does allow for a vote.
All right.
And I know that the House rules do allow if 20% go with a recorded vote. I would like the yeas and nays recorded.
Let me confer. Mr. Knox, you got any advice on this matter?
Does he need a second?
Chairman Franklin seldom wrong about these matters.
All right. I am going to, on your appeal, I am going to continue to assert that the matter is germane. If you want, it is not germane. And if you wish to have a vote on that, I'm going to allow a vote on it. Well, that's true. There is not a second. Is there a second? Thanks, Tom. All right.
No,
All right.
it's on the appeal of
All right. So All right. The issue is, as I understand it, before the committee is whether or not the committee believes that the proposed substitute is germane to the bill. That is the issue for the committee to decide. It has nothing to do with the merits of either bill. Is there any further discussion? Yes, sir.
Is there a majority vote that would overrule the ruling of the chair, or is there some other requirement?
I believe it would be a majority vote required to overrule the ruling of the chair. I do not.
During the back of your book, it's not provided about the but it's in the back of your committee book.
All right. Any further discussion? No. If there is no further discussion, all those in favor of the chair's ruling, raise your right hand.
All in favor of the chair's ruling? raise
Of
your
the
right
chair's
hand.
ruling that this is not a germane amendment. All right. And all those opposed?
I'm used to the Abrams-Franklin coalition,
All
not
right.
the Mangum-Franklin
The chair
coalition.
has ruled that the amendment is not germane. That has been supported by the majority of the committee. The amendment is therefore not germane and will not be further considered. Returning to the main bill, is there any further discussion of the main? I think there was already a motion.
Second.
I believe there's been a second. Is there any further discussion of the bill?
Mr. Chairman, could you rule on the germaneness of how stealing a dog collar is germane to a prohibition on animal fighting?
Yes, I could. I believe that it all deals with dogs, which are canines, and therefore they're the same subject matter. All right. Is there any other discussion?
Question, Mr. Chairman.
Yes.
I did ask a person I thought would be knowledgeable of it, and someone just brought up the issue that it would apply to all domestic dogs, and I'm wondering why would that be a problem? Because I don't want my domestic dog, stolen either. Could I at least hear from that young lady, or because we will have a unanimous vote on this?
We have a motion, and we're discussing it amongst ourselves. The time the question is over.
All right.
I'll leave that up to each and every member as whether or not they think that's a good idea. All right. Are there any other discussion of this bill? All right. Seeing no further, I have some lights over there. Miss Abrams, did you have any further discussion?
So what does it matter if it's a hunting dog or a...
I know they're putting little shipment dogs in.
Yeah, that's a good thing.
All right, all those in favor of the do pass recommendation as, let's make sure we got it right. LC 293370S to substitute to SB 16, raise your right hand. All right, thank you.
Now you want to do against?
Any opposed? All right. Thank you very much, Mr. Williams. It'll be reported do pass. Number 3 is Rules of the Road, SB 438, Senator Mullis.
Mr. Chairman, what a pleasure it is to come before this outstanding committee this morning with such powerful members. I'm humbled, truly humbled. Thank you for hearing me. I think we're working, Mr. Chairman, off of a Senate substitute that Representative Sims has some additional language to, and I guess we're working off of LC 255280.
Okay. All right. Do you wish to explain the bill, please?
Yes, sir. Mr. Chairman, this legislation creates a second offense penalty for causing serious injuries during a right-of-way violation, resulting in a collision with a motorcycle, pedestrian, bicyclist, or a farmer hauling agricultural products. This is a bill to help our friends who enjoy their motorcycles and walking. And with the price of gas, I would suggest to you there'll be more people involved in those activities. There's some questions that have been brought up to me this morning, and I'd like to talk about that. On page 1, line 22, legal counsel has suggested that we need to eliminate this language, and I would agree. After $50 to mark out and submit proof of completing a department-approved driver's improvement program. It's not mentioned anywhere else in the bill, and I believe that it's not needed in this.
All right. Could you pull that microphone around to you? Thank you. No, we got it.
Thank you.
This better?
Yes.
All right. Sorry, Mr. Chairman. Also on page 2, line 11, we need to remove "or death" because we feel that it may interfere in that being construed as a misdemeanor, which is a less serious violation for such a tragedy. Mr. Chairman, that's all I have that is part of the original bill except Section 3, which is, I think there's some speakers for that Representative Sims wanted to add on to it, which I have no problem provided the committee has no problem.
All right. Is Representative Sims here to speak to 3? Okay. I understand there are some other people signed up. I guess they're here to talk to Section 3.
I believe that's correct, Mr. Chairman.
Okay. Is there anybody signed up on this? No. Okay. All right. All right. Are there any? There's nobody signed up on the bill. So, if there are any questions from any members of the committee? Yes, ma'am.
Thanks, Senator. And I'm just looking at the bill for the first time.
Yes, ma'am.
If you could just explain what the existing law is and what you're strengthening.
Okay.
That's right. And
Penalties
for right-of-way violations regarding this activity.
So what is the current penalty and what are you trying to?
Is that the motorcycle?
Well, the current penalty is
on the other part.
is $250 to $500, and we're moving it up to $1,000. That it can go up to $1,000. And let me stress that this is only in regard to a right-of-way violation. That means, of course, that the motorist is guilty of or have been accused of that. And, of course, the court will determine that guilt or not. But if the motorcyclist or pedestrian or bicyclist is guilty, then there's no additional fine. It's only when this has already been occurred and the motorist has been cited for a right-of-way violation.
Further clarification.
Yes.
Existing law is a misdemeanor fined by no less than $250. No less than
Yeah. Well, the new language is for the second offense.
So the new second or subsequent offense within 5 years, it's still a misdemeanor.
That's correct.
But now you're looking at $500 to $1,000.
That's correct.
10 days to 12 months in jail. Is that correct?
Yes.
Not waive the fine under any circumstances.
That's correct.
Okay. Thank you. I just wanted to be clear on what you're trying to do.
Thank you, Representative.
I've got I guess it's Mr. Ramsey.
I'm looking on page 3, the addition you're making. Just so I'm clear, so if somebody drives a 4-wheeler, they have a creek on their property and they drive a 4-wheeler through the creek, they're subject to penalties unless they get permission from every single upstream owner of property that a piece of that creek runs through?
Mr. Ramsey, I don't know because that's not my language. It's Representative Sims, and there's
that's what we're waiting on.
Yeah, and I apologize for that. I think there's some folks here that can speak on that.
Yeah, in fact, Mr. Dowling is here. Maybe he can address that. I'm sorry, Mr. Dowling, we did not see you on our list a moment ago.
Committee, my name is Glenn Dowling.
Come on up here where you can talk into that microphone right there.
Mr. Chairman, members of the committee, my name is Glenn Dowling. Thank you for the opportunity to speak to you this morning. I'm the Executive Vice President of the Georgia Wildlife Federation, one of the oldest and largest conservation organizations that is sportsman-based, representing more than 40,000 hunters and anglers in the state. Section 3 on page 3, we are strong supporters of that language, as this is for the first time where we see some relief to property owners for their private property protection from illegal trespass by the use of off-road vehicles. It also has the quality of providing protections for fisheries habitats statewide. The question is, if in a non-navigable water, if a property owner is going to have permission from upstream property owners to ride in the stream on their property, the answer is no. This protects the property owners from other people trespassing on their property using a creek as a travel way, trespassing onto their property. What this says is the property owner that owns the land next to a stream or on both sides of the stream has to give someone permission to actually ride in that stream with an off-road vehicle. They can do as they please. This protects the property owner themselves, and it protects the property owner from other people who trespass using the stream. Let me give you this example. My family owns a farm in Terrell County that's bordered by the Itchaway-Notchaway Creek on the western border. We also own the land on the other side in Randolph County. We have people who access that creek from other properties and ride up the creek, trespassing onto our property, damaging the fisheries habitat, potentially poaching and escaping without our ability to catch them. We have stewarded this creek and this fishery for more than 20 years, and we want to protect it. This is the first time that we have language that will protect our private property right while allowing us the ability, or the farmer next door that has cattle, if he needs to use an off-road vehicle to cross his creek or go to get his cattle or harvest timber, whatever, he can do that. This language allows that.
There's several questions for you that are popping up. I've got a question myself. Looking at page 3, line 13, it does appear that it seems to be without written permission of riparian owners of adjacent upland property or their agents. What is the definition of upland property?
That's the adjacent property next to a creek. That's just the upland property adjacent to the buffered area, the riparian area of the creek.
Is that defined in the code elsewhere?
I would not know that answer.
Do you know, Jill?
That's navigable and non-navigable waters. Okay. I could give you the definitions of both non-navigable and navigable streams if that might help.
I'm personally familiar with those, but I don't
see any definition for the word upland property is not used in the code at all.
Okay. In a non-navigable stream, doesn't the property owner own the non-navigable stream?
They own the beds of non-navigable streams belong to the owner of the adjacent land. If the stream...
If you own both sides, you own it all. If you own one side, you own half
to
of
the
it.
middle line of a non-navigable stream, to the center line of the non-navigable stream. Correct.
All right. Mr. Ramsey, did you have a question?
Well, I guess I'm just trying to your explanation. Your concern is to deal with the creek that runs through your property, right? Your farm in Terrell County.
Okay.
Is that the reason this language was added?
No. This language actually addresses the issue of the problem of illegal trespass statewide and the destruction of fishery habitats statewide.
No, I understand. I'm just talking in the context of the
River.
Hypothetical.
The hypothetical, yes. It protects any property owner that has a creek or a river running across their property from the illegal trespass and use of an off-road vehicle to access that river to travel upstream or downstream and potentially trespass, to poach, to escape, and in doing so they're damaging vital fisheries habitat in state waters, statewide.
But if the creek or if the water runs through your property, there's already a provision that says you can't be on private property without the express written permission of that property owner. That's already in the code.
What happens is, I'll give you another example. Highway 82 at the Satilla River in southeast Georgia and Brantley County. People they'll unload their vehicles at low water, and when that Blackwater River comes down, they'll ride for miles up and down that river on sandbars where people own to the low water mark of that river. So they are literally trespassing, but the problem is catching them. But that's the problem. So if the sheriff sees them at the bridge riding in the river, they now have a tool to stop them and prevent them from doing that. But the prevention is what we're after.
Again, if they catch them on private property, they're in violation of the current code.
That's trespass. This is another tool in the toolbox for law enforcement to help property owners statewide to prevent that access and to also support the prevention of the destruction of fisheries habitat, whether it's cold water streams in North Georgia or flat water streams in South Georgia, where the illegal or inappropriate use of four-wheel off-road vehicles are damaging the fisheries habitat statewide, and this needs to be stopped.
I guess
this language will do that.
I guess the way I read the language is if I own a piece of property with a creek running through it, and I want to cut across that creek, I'm not going to be able to without getting my neighbor's written permission first.
No, if the property goes through your property, you have your permission to go across the property.
Well, but it says right here, I can't. I'm in violation of this code section if I operate an off-road vehicle within the banks of any non-navigable stream or waterway without written permission of the riparian owner of adjacent property. So, in other words, if I cut across
of adjacent upland property, the owner of the adjacent upland property, the owner of the land next to the property. In other words, I'll give you the example.
The owner of the adjacent property next to me.
No, you're talking about the land that you own adjacent to the riparian owner of adjacent upland property. You own that upland property, and I'll give the example. You own a farm, and I lease the deer hunting rights. And in that, you give me the ability to use my four-wheeler to cross a creek or to retrieve an animal that's in the creek. I can use that vehicle to go use that creekway to hunt or to fish or to cross over. If I lease let's say I put cattle on your farm, I can go across that creek because I have your express permission because you are the riparian owner of all that upland property adjacent to the river.
I'm going to defer to other members of the committee and hope they can figure this out.
Thank you. I believe Mr. Lunsford.
Thank you, Mr. Chairman. I was hoping that Jill could answer this question for me. Sorry, Jill.
She is an expert on these ATV
She
matters.
is an expert, Mr. Chairman, on these ATV matters. Page 3, line 8. If I'm a private property owner, I have just said that I have committed a violation of this code section if I drive a four-wheeler on my own property without a muffler. Is that correct? Because it says any violation. If any person operating an off-road vehicle under any of the following conditions shall be deemed a violation of this chapter. So even if it's my own private property and I'm operating an ATV without a muffler, I've just violated.
It looks to me to be interpreted that way, and I suppose that's a break that your neighbors would want you to be.
Yes, ma'am. I'm not real concerned with my neighbors.
Code, though,
They're saying line 1 is current code. I've got a question for you, if I could, Mr. Chairman, if I could follow up.
Yeah, sure.
When we're talking about the riparian rights, now I think under current Georgia law, the property owners adjacent to the stream would own to the center of the stream each, and then you'd have the right to pull water as long as you didn't pull more than your share from the property, and there's a whole water rights issue that goes with that. But in your scenario that you're depicting, where your family owns both sides of the stream, under current Georgia law, there is no public right-of-way there. You actually own both sides of it anyway. So why could you not, under current code, have that person arrested for trespassing now?
If you can catch them.
You don't really believe this piece of paper will catch them?
It's going to help stop them before they get in the creek. It's going to stop them. This is another tool in the toolbox for law enforcement to enforce before they even start into the creek at bridge crossings and right-of-ways of roads and rivers. The property owners are not the problem here. The property owners, riparian property owners statewide, protect the river, protect the streams and creeks. They don't want to damage it. It's those who are trespassing and those who are using the inappropriate use of off-road vehicles. This is another tool where law enforcement can stop that behavior before it even happens. That's the dire need statewide.
I have a question, if I could follow up one more time, Mr. Chairman. On line 12, within the banks of any non-navigable stream or waterway without written permission of the riparian owners of the adjacent upland property, what if you own one side of the stream and you determine that you want to ride your four-wheeler up the stream that you own legitimately to the center line? Now, if it was a navigable water, you own to the high water mark, but on a non-navigable stream, you would only own to the center line. And your neighbor says, no, I don't want you riding in the stream.
You'd be on your side of the river, your side of the creek.
That'd be a pretty big creek.
Well, they come in all shapes and sizes in
Okay.
Georgia.
I was just curious. Thank you, Mr. Chairman.
Mr. Knox, did you have a question, or were you going to propose some amendments?
Well, I have an amendment, but I had a couple of questions to be sure whether or not we needed the amendment.
Let's stick with questions right now, if you don't mind. Questions.
Okay. With respect to the, first of all, I guess a question to the chair would be whether or not the 3 and 4 constitute matter that's related subject-wise to the main body of the bill. Looks like we're dealing with in the bill a issue about right-of-way, traffic right-of-ways, vehicular traffic right-of-ways, and traffic laws. And I'm not sure this is the same thing that we're dealing with here. Looks like this is an issue about riparian water rights, basically, and land trespass or trespass to real property. And I'm not sure whether or not those are related at all. That would be my first question. I could direct that to the chair if the chair is.
Just looking at the bill, I noticed that the first sections are dealing with 40-5-57.3, 40-6-77, and this appears to be in 40-7-4 and 40-7-6. So, I don't know if it's in the same chapter or not. Can somebody get me a copy of 40?
It's consecutive chapters.
Consecutive chapters,
Yes,
is that what it is?
And if I might,
Even Mr. Chairman, if I might,
Yeah.
even if the language is drafted as though it belongs to that chapter, that doesn't make it relevant subject matter. That just happens to be how it's labeled, and that's my question: is whether even if this is the same chapter according to the labeling in the bill, that doesn't necessarily mean that the subject matter is the same, or should even be under 47 or whatever. That'd be an issue that I'd have with it. But I have some other questions other than that. If you want me to go ahead with those.
You're asking me to make a ruling on
I will, but
this?
if you need some time to look at it, I'll ask some other questions. You want me to go ahead with my
Go
question?
right ahead.
All right. With respect to number 3, then, within the banks of any navigable stream or waterway, if the purpose of this is to keep people from riding up and down in a waterway, not crossing a waterway, but riding up and down in the waterway, isn't that already a violation, or wouldn't that require? Let me back it up. Wouldn't it require, if they're riding below the high water mark line, which is typically where they would be riding, I would expect, or else they're going to be riding on an angle that probably a four-wheeler couldn't sustain if they're riding parallel with the bank. Wouldn't they be riding on state property anyhow?
if that were in a navigable stream,
yes,
it would be state property. And take, for instance, the Blackwater rivers in southeast Georgia have a lot of sandbars, lower Altamaha, Sotillo River, and some of those. It's very easy for a four-wheeler. It's quite flat, and there's a big problem with trespass and the damage of the natural resource of the state waters in that part of the state. When you get up into North Georgia, it's smaller, rockier streams, but you're dealing with a much more sensitive ecological habitat to trout fisheries that are being damaged as well.
Well, in that case, wouldn't this be a requirement then in this bill with the addition of line 3? Wouldn't that require a person to get the written permission of the state of Georgia to ride on those navigable streams below the high water mark?
No, sir. This says that you will not be able to ride in navigable streams. And it's beyond me why someone would want to ride in a navigable stream. Navigable streams are for fishing, floating and fishing, versus driving an off-road vehicle through a navigable river, which, by the way, would be much more difficult to traverse in a vehicle than a non-navigable stream.
Okay, well, I'm saying that it says that you'd be in violation unless you get the written express permission of the owner of the property. I think that's the state of Georgia if you're below the high water mark.
That's only in the non-navigable section.
Right, that's all I'm talking about right now.
Just non-navigable. Not in Chapter 3, if you're in the navigable stream, it's a violation. Okay. It's not a violation in a non-navigable stream if you have permission of the landowner.
Okay, then, so number 4 is the one I'm really addressing, and I maybe got confused. But
okay.
Number 4 would be a navigable stream below the high water mark. In order for me to be able to ride on that property, I have to get the permission of the state of Georgia below the high water mark, and I have to get it in writing to be able to do that without violating the law.
No, sir. Number 4 is non-navigable stream, where property owners would own to the center line. that would not be state property in the non-navigable stream.
All right, well, let me try it again then. That's what I'm having a problem with this because this is very confusing the way it's written, I think. So this says, let me see if I'm reading this right. Says any person operating an off-road vehicle. Now that isn't necessarily an ATV.
Right,
that could be a Jeep or whatever vehicle you use.
Yes.
If I'm deer hunting, for instance,
Yes.
and I've got a pickup truck that I use to go off in the woods and hunt turkey or something like that.
Yes.
Any person operating an off-road vehicle under any of the following conditions shall be deemed to be in violation of this chapter, subject to penalties and so on, and then provided it's without operative brakes or without mufflers, and then 2, on any private property without the express written permission of the owner. Now, on number 3 then, is the owner of the property the state of Georgia with respect to the property in the bed of the stream below and between the high water marks on each bank?
Correct.
Okay.
But it doesn't. The language doesn't require there to be any permission. There is no permission. Off-road vehicles will be expressly prohibited from navigable streams.
Show me where you're getting that from.
Within the banks of any navigable stream or waterway in this state. The difference between 3 and 4 is either navigable or non-navigable.
Yeah, I understand that.
Okay.
But my point is, where does it say in this code section that it's against the law to do that, except with the provision of these first 2, 1 and 2, which is the current law? It says it's not a violation if I have the permission of the property owner in writing, and if I've got brakes and a muffler, I can ride in those. It's not a violation of the law then, correct?
The express need here is to keep off-road vehicles out of navigable waters of the state of Georgia.
But that's not my question. I understand what the intent is. My question is what the wording in this bill says.
Okay.
And I don't think that I think what the wording in this bill says is that it's not a violation.
Oh, I see. When you're going on number 2, express permission of the owner of the property.
That's right. It's not a violation of this code section if I have operative brakes, mufflers, and silencing equipment, and I get the written permission of the owner of the property.
Yes, sir.
Okay. So in that case, wouldn't it require me then, with respect to number 3, to have in writing the permission of the state of Georgia to operate my vehicle on that property that's owned by the state of Georgia, i.e. the property between the banks at the high water mark?
It would appear so, and I would ask that you would potentially ask for legal counsel to answer that. But the answer that I would give is yes, you'd have to have permission of the state to operate a vehicle on state-owned property.
And that would include going across the river too, would it not?
It'd be difficult to take a vehicle across a navigable river.
Well, sometimes around here you can go across the Chattahoochee and it's navigable in a lot of places, and other places it isn't. But when the water's down the way it is now, you can probably go across it in a lot of places.
We would suggest in navigable waters it would be a place that would not necessarily be conducive to taking off-road vehicles.
All right. Next question is, with respect to what we have characterized here as adjacent upland property of their agents, as I think you described this earlier in your testimony, upland property is not property that borders the stream itself, but property that borders the property that borders the stream. Is that correct?
I don't know the definition of upland property. The language that was written here that was proposed by Representative Sims was to be the adjacent property, the property owner by or through which the stream crosses.
I'm not sure how that's different than a riparian owner of property. Riparian owners of property are all the owners along the waterway that have property along the waterway. That's the only people that have riparian rights in the water. That's what we're talking about. I'm not sure there's even there is such a thing as a riparian owner in the code. There's an owner of riparian rights in the waterway. I think that's what the law says. Am I right about that? Is there such a thing as a riparian owner in the code?
It's not a defined term, but it's sometimes called riparian buffers and sometimes called. I have seen riparian owners. I've not seen it defined, but I see it being used in health well.
Okay, because I think riparian rights refer to the use of the water and the possession of the water, not necessarily that you own the water, but that you have title or right to use the water. That's what a riparian right is. That's a different proposition than owning the water or even owning land under the water or next to the water. Those are different. I think those are just ways of describing your right to use the water. So I don't know how adjacent upland property qualifies the term riparian owners or riparian rights, either one.
Riparian rights extend to water law in the state of Georgia. The riparian owner refers to the buffer, the area next to the stream that is the riparian area of the watershed or of the waterway. And to address the potential germaneness of the bill of these being consecutive chapters, where the rivers cross the right-of-ways of county roads, state highways, that is where a lot of this inappropriate traffic takes place and it is initiated. So it's quite germane to how we get to the problem and how we stop that behavior.
I understand where you're trying to get to. You just have to get there the right way, and that's what I'm concerned about.
I agree. I agree.
Ms. Abrams, did you have a question? Mr. Collins, did you have a question?
Yes, Mr. Chairman. Taking off the discussion that's been going on concerning riparian rights and the other things, I want to go back to just more of a definitional issue here, because I think it hits into some of the other things. But navigable, just the term navigable.
Right.
All right. When applied, I know, especially when the Corps applies it, which I know is also mimicked in the state code as well,
right,
that is a very broad term. And my concern here is, and I understand from what I've listened to and seen here, the problem is determining the difference between a navigable and a non-navigable stream. We have this issue, and it come up in the state water plan up in Hall County, White County areas where we've got quote, they've been listed as navigable streams that are an inch wide. Okay? There are runoff areas that have been determined as navigable. These are the issues that we're dealing with in other areas, determine what statewide water plan, other things like this. I'm not trying to sort of disrupt here. However, I have a concern. Your very thing was we want to keep people out of these. Well, my point is, when do you start? How would you, an officer who not familiar with these terms or taking into account the legal definition of navigable and non-navigable, how are they going to determine which is which?
That determination is a good question from a lot of people, even that work for the state, is what is a non-navigable and navigable stream, and how does an officer of the law determine that? With this language, if a county sheriff or state patrol were to witness someone coming out of a stream bed onto the right-of-way of a highway or a county road, they would have used that, either one, a navigable or navigable stream if they're in a creek bed, okay, regardless of its definition. The point being is, if it's navigable, they violated the code. If it's non-navigable, they should have the written permission of the landowner, and if they don't, they're in violation.
So
stopping the behavior.
So we're going to ask an officer basically on the side of the road to go through a process of saying, one, okay, I'm determining this is navigable. All right, one, I'm not sure how he's going to do that unless it's been marked. Two, you got a non-navigable. He's going to have to go and say, do you have permission of this? Like I said, I understand, I think, what you're trying to get at here. The practicality on this, on the officer who has to enforce this, not us in this committee meeting talking about grand ideas of riparian rights and everything else which go into this. This is just a practical issue because we're having trouble with this in defining, because when you get into the navigable and non-navigable issues, you've got 300-foot buffers, you've got 150-foot buffers, you've got all kinds of issues that go into this. So I'm just looking at the guy on the street saying, how do I enforce this?
I think the way to enforce it is that if someone is riding in a stream and they are off a state right-of-way on a stream, either they should not be there or they should have permission of the adjacent property owner. It's one or the other, and if they don't have permission, they violated the code.
Thank you, Mr. Chairman.
Thank you. All right, are there any other questions for I don't see any other questions. I have a question, however, for council. Is there a definition of banks? No. Nowhere in the code? In the dictionary?
I'm sure in the dictionary. Just again, I'm fishing around in chapter 12, in title 12, buffer is a defined term. Buffer means area of land adjacent to the banks of state waters in its natural state of vegetation, which facilitates the protection of water quality and aquatic habitat. So I mean, I wonder if buffer is a better word. I'm not a big Title 12 expert.
Yes.
In dealing with that, and again, I go back to this issue because we've had to deal with this a great deal in Hall County and dealing with statewide water plan. The issue of buffer and banks, it can vary dramatically. I can take you to a stream that can be considered navigable, maybe under your definition, or non-navigable, and actually the bank where they start the buffer could be almost 200 feet away from where the actual stream is, depending on the grade of the land.
Mm-hmm.
So trying to come up with a term where the bank starts and where the bank ends, the buffer begins and where the bank buffer ends, you could try to use the common sense test, but when you start putting it into code, you're going to get into trouble with that because it's going to be challenged legally, and then where you're going to be at that point.
Well, I like the idea of the bill, but I'm getting a little bit concerned too because I'm very familiar with some of these South Georgia streams where especially when the water is low or the tide is out and there are naturally exposed sandbars. If you say the banks, I mean, if I was defending somebody doing this, I would say the bank was down there where the river was, and I was up on the sandbar, which was beyond the bank. So it's troubling a little bit. All right. Are there any amendments or further discussion of this matter, Mr. Knox?
I'd like to be recognized for an amendment at the appropriate time, Mr. Chairman.
Are you still standing on your germane question?
I'd be happy to hear the court's. I mean the the chairman's ruling.
I've looked at it, and frankly, it's a different chapter, and I don't believe it is germane.
I think the process would be a motion then to strike the amendment or the addition at 3 of, I guess that's paragraph 3 and 4, or subsection 3 and 4. Is that what it is, Jill?
Well, I think you want to keep the repealer, which is section 4. You want to strike section 3 and renumber.
Oh, okay.
Do you have that in your folder?
I don't see the original.
That's all right.
No.
Mr. Chairman, if I may, due to the waning days of the session, we try to accommodate our House members and also good issues. So I appreciate the diligence of this committee. But my main purpose is, of course, to pass the original bill. Yeah.
All right. Do you have, having ruled that this new section not to be germane, is there a motion regarding yes?
I'd just like to discuss the germaneness a little bit.
All right.
More. I'm no expert on germaneness.
I'm not either.
I reviewed that provision recently. It's in the House rules. I don't have that rule book in front of me, but the definitions I recall, it's not just in the same code section. It's dealing with similar issues. It is vehicles. I'd like to see this provision. I don't want to mess up your bill.
Well, I like this provision too in some ways. I'm just concerned about
I think it's
the language of it. I'm all for protecting trout streams from people riding through them and that sort of thing.
I'm just wondering, perhaps we could keep it. I mean, it's always possible to have a rules committee amendment if some of these issues can be resolved.
I'd like to be recognized for that motion.
So you don't have a motion at this time?
I understand the concerns about the definition of a bank, but I do like the intent of what's trying to be pursued here. I think it's good. The intent is good. It's just working out the details.
All right. I think is this for comment or amendment?
It's a question.
All right. Go ahead.
I would share Representative Ben's concern about ruling this non-germane, given that it's in the same chapter and because it is dealing, even if it's in an attenuated fashion. I'm concerned about the fact that twice today we've dealt with germaneness, and I don't want us to create a system of determining germaneness that we have to stick with going forward. I agree with the earlier ruling, but would be very concerned about making certainly I support the amendment, but would understand if we want to strike it, but would hope that we would strike it simply as a matter of course, not as a matter of germaneness.
All right. Well, all right, number 13, Mr. Franklin.
Yes, I would like to offer a motion to adopt to give due pass to Senate Bill 438 as it came to us from the Senate.
I second that.
Okay. There's been a motion and a second.
Mr. Chairman, we need to consider the.
There are some amendments that were suggested.
Yes.
Let me.
I'd like to recommend your substitute motion.
All right.
I'd like to substitute a due pass motion for LC 25528.0S.
Second.
Okay.
That's the non-germane one.
What's that motion?
All right. Going to.
She's moving what?
Substitute motion on this.
Oh, okay.
All right. Going to the last motion first. Now, you're making that without the amendments that the author suggested.
I'm happy to make it with the amendments that the author suggested.
Well, why don't you
So I would,
amend your motion to at least include the amendment that says your motion.
I'd like to pass on LC 25528.0S, amending line 22 to strike after $50, striking from the word "and" on line 22 to the comma on line 23, and on page 2, striking on line 11 the words "or death."
Thank you.
All right. And those are acceptable amendments to you, is that correct?
Certainly. Yes, thank you.
We're going to consider then those amendments to have been friendly and accepted by the author. The question before the committee now is whether to vote on the bill as LC 2552880S. There has been a motion and a
Non-germane
second
portion in it.
to that.
Mr. Chairman.
Yes.
We're going to take this out just a step further. I'm going to make a substitute motion to Ms. Abrams, striking Section 3 and renumbering appropriately. But to your motion, I'm make. No. Okay, then I can amend your on your motion. I'm moving to amend the bill LC 2552880S on your due pass recommendation. I'm amending hers, Abrams. I'm amending the bill. Correct. I'm bringing it back.
Second.
I'm sure glad I got to do this.
I'm just amending the due pass motion by Representative Abrams, LC 2552880S, by striking Section 3, renumbering appropriately.
Second.
All right, we have a question from Mr. Beard.
You can't strike Section 3.
By striking Section 3 in its entirety,
yeah, you're going to
you're taking out current law, which states on any private property without the express
right.
written permission of the owner. By striking all of Section 3.
Yes, you are.
Yeah, you are. That's current
Section
law.
3 includes all of that language on page 3.
Doesn't the original motion do the same thing as the intent of Mr. Collins?
Doesn't have the friendly. The original motion did not have the friendly amendment.
The original motion did not have the friendly amendment.
Right.
Hers has the friendly amendment.
Okay.
Mine takes out. I tell you, now what was the answer concerning? Because if hers goes back, his motion would have to change to after a due pass. Then it's over. So that's why I'm going back to here.
All right.
It's got to start right here.
Okay.
So, but the question I have, and it's Mr. Bearden's question, and I'm taking care of now. Are we okay with?
We're okay.
Okay.
All right. I think Mr. Setzler wanted to weigh in on this matter.
Mr. Chairman, I actually have a parliamentary inquiry for the chair.
I like those.
I would just ask the chair if there's a posture, and I know we're moving forward with these parliamentary flanking movements here. If we could just get on the table an up or down vote on Section 3 and then move for consideration.
You're going to take out existing law if you take out all of Section 3.
All right. Now, I think somebody over there.
That's me, but I'm going to wave for the moment.
All right. Now, I don't have anybody else.
I'll just take it.
Everybody. All right, Mr. Collins, for clarity, would you please restate your motion as you understand it?
A motion to amend LC 25528OS included in the friendly amendments were included in that. And then it's my understanding that we'll just take section 3 of this language out and renumbering appropriately.
All right. All right, does everyone understand the motion? All right, is there a second to his motion? Second, all right. Is there any further discussion of Mr. Collins' motion? Yes, Ms. Abrams.
I'd like to speak against the motion to amend LC 25528OS.
All right.
I believe that the section 3, while there are some additions, I think there's some language that can be further improved given the lateness of the hour, but given also the importance of this language. I think it's critical that we move this forward with the language intact. I believe the language can be amended. We've done that on several occasions. I think there's certainly there's a great weight to wanting to protect our streams, wanting to meet the environmental needs of the state of Georgia, and I think this is critical and important language that should move forward, and I would ask that we oppose the motion to amend.
All right, thank you very much. Now, does that set it up for everybody? Is there any further discussion? Seeing no further discussion, all those in favor of LC 25528OS as amended by friendly fire first, and then subsequently having
No, you're just voting on the amendment to strike.
on the amendment to strike section 3. All those in favor, please raise your right hand. All right, those opposed. All right, 7-5. So the Collins amendment has failed. All right, the motion passed. Excuse me, I apologize. I'm sorry. Has passed. That means that Section 3 has been stripped out of the bill. All right. All right, there's a motion to reconsider.
Well, we have to vote when they're here. We can't go round people up when we're in the middle of the vote.
All right, there's been a request to reconsider. I'm going to allow that to happen. We're going to have a reconsideration. All those in favor of the Collins amendment, which strikes Section 3, please raise your right hand. This is the motion's to reconsider? All right. All right, all in favor of reconsideration, vote. A or nay? All right. 6 in favor. All those opposed? Okay, 7 opposed. So is that correct? So the motion to reconsider has failed, correct? All right. All right. We are now on the main bill. Is that right? Or we've already? All right. We're now on the main bill. All right. It's sections 1 and 2 without section 3 as amended with the friendly amendments that were made to it. Yeah. And the renumbering. You got that, Jill, with the renumbering? All right. I'm glad you are, because I'm not. All right. Is there any further discussion? All right. All those in favor of the motion do pass, please raise your right hand. For the committee substitute, LC 25528OS as amended. As amended. All right. Yes.
Would a substitution reinserting the stricken provisions be in order, Mr. Chairman?
It's been voted on, reconsidered, and failed. I don't think that would be appropriate. All right. So I think we're concluded. All right. All those opposed to the due passage of the bill. I thought we were unanimous before. Is there somebody opposed? All right.
Mr. Chairman, I want to thank you for this exciting experience.
Well, you know, it's really been a lot more exciting for me than you.
But I truly want to thank you for this. Let me know, Mr. Chairman and members, how the Senate Transportation Committee can serve it. Representative Bill Hembry will be taking.
Thank you. Can you do 529 first?
Yeah.
Give me a chance to go get a cup of coffee.
Do you want to be recognized, Representative Setzler? Your light was flashing. Okay. Oh, maybe it was you. Well, I should have got back sooner. I have a report to make from my visit to Senate Judiciary. That's a great place to be, y'all. I hope y'all have an opportunity to get over there soon. It's a great, great place. Senator Grant. On Senate Bill 529.
Thank you, Mr. Chairman. I do bring before you Senate Bill 529. This need to be... Is it on?
Yeah.
Okay. Senate Bill 529, and I have with me this morning District Attorney Fred Bright from the Okmulgee Judicial Circuit. He represents most of the counties of my 10 counties senatorial district, and he's been quite a support and help on bringing SB 529 to you today. I also have Sheriff Howard Sills from Putnam County. Sheriff Sills has jurisdiction over part of Lake Sinclair, and some of the bill originates with a case that happened on Lake Sinclair. Senate Bill 529 corrects a loophole in Georgia statutes regarding deaths resulting from hit-and-run accidents. On your desk this morning is a copy of a Morris News Service story written by Josh White that helps explain the issue. To quote the article, the bill, which applies both to motor vehicles on public roads and boats on public waters, would ensure that any driver who kills another and doesn't offer help will be charged with first-degree vehicular homicide no matter when the victim dies. This problem was brought to my attention by one of my constituents, Sandy Baxter, who lost her husband in a hit-and-run boating accident on Lake Sinclair in July of 2006. Ms. Baxter is here in the audience with us this morning as well. In March of 2007, when the trial that arose from the Baxter accident was being held, the Georgia Court of Appeals rendered a ruling in the Gwinnett County case of Henry v. State. A copy of that Court of Appeals decision, number A06A2389, is also on your desk this morning. In the Henry v. State case, a 14-year-old boy was struck and killed while riding his bicycle. In the subsequent trial and appeal, the defendant, Michael Henry, argued that the state failed to prove that his failure to remain at the scene contributed to the death of the victim. The Georgia Court of Appeals, in their March 2007 decision, agreed with the defendant that his failure to stop and render aid did not cause the victim's death. That Court of Appeals decision directly led also to an acquittal in the Baxter case regarding first-degree homicide by a vessel by failure to stop and render aid. D.A. Bright had other charges against the perpetrator, so that did not, while it contributed to the case, it did not completely blow his case against Mr. Intrican. My constituent, Mrs. Baxter, wrote me a letter immediately after the trial where she stated, "My family and I were appalled to discover that Georgia law allows for hit-and-run drivers in vehicles and vessels to leave the scene of an accident as long as the victim dies instantly, or it is proven that stopping to give aid would not have saved the victim's life. However, the leaving the scene is a felony if the victim survives or lives for a short time. We cannot comprehend such a law. How would a fleeing person know if a victim is dead or dying? After SB 529 was introduced and began to receive some press, I was contacted by the parents of the 14-year-old boy that was killed in the Gwinnett County case. They write that they have lived the judgment of this decision in shock and disbelief. The victim in Henry v. State was a wonderful young man of 14, very caring, bright, and months away from entering high school. Jeffrey was killed, and as mentioned, he died on impact. This young man was our son, they go on to say. Now that we read today that other cases are being decided due to this ruling, it breaks our heart that these families are experiencing the same loss of judgment and closure. Every human being has a moral obligation to stop and render aid. Responsibility must come before trying to hide or run like cowards. I believe that the Court of Appeals agrees with the Baxter and Shirley families that this was not the intent of the original legislation. In their decision, and if you look on page 3, you'll see this, they quote an earlier ruling in Claub versus the state. It is nonsensical to require that a driver's action in leaving the scene cause the victim's injury or death. If this were the rule, if a victim died immediately after impact, a hit-and-run driver could never be charged with first-degree vehicular homicide through a violation of OCGA 40-6-270B, because there would never be any evidence that his failure to stop and render aid caused the victim's death. Regardless of our personal views of a fair penalty for such callous and craven conduct, it is the General Assembly's role, not ours, to determine whether a hit-and-run driver who could have prevented an injured person's death by fulfilling the duty to stop and render assistance should be punished more severely than a hit-and-run driver whose help would have made no difference. Thus, the Court of Appeals calls on us as members of the General Assembly to correct this loophole. In closing, I believe that someone who kills a person immediately and then flees the scene should not be treated less harshly than someone who flees the scene and then has their victim die hours or days later. I thank the people with the Legislative Counsel's office who helped draft this bill, which I do believe helps close the loophole. We have had the second floor, the legal counsel for the second floor look at this, and they seem very happy with it. I think there is someone who will speak today that offers an amendment, and on first blush, the amendment does seem to be innocuous, maybe even redundant, but on further consultation, we think that may end up creating some problems with and undo what we are intending to do with this particular bill. So I would not support an amendment, that particular amendment to this. If there are no questions, I do have D.A. Bright and Sheriff Sills here that could explain details of the Baxter case or speak to some of the provisions of the law.
Thank you, Senator. You do have a question. Representative Levitas.
No, Mr. Chairman. At the appropriate time, it's a very small amendment at the appropriate time.
Representative Bearden.
Just going to ask on page 2, line 23, you got imprisonment for not less than 3 years or more than 15 years. And on page 4, line 3, you got imprisonment for not less than 2 years, no more than 15. Why aren't they both 3 years?
That's current law. Yeah, if it's the committee's will to make those equal, then
the first one deals with vehicles. It's homicide by vehicle in the first degree, and the state of the current law is no less than 3, no more than 15. The second one is boats, vessels, and that's 2 to 15. So right now, the maximum is the same, 15. Yeah. The minimum is what's different.
But currently, it's still
and that's current law. We have not changed that. But if it's the will of the committee to change that, we would not object.
Okay. Any questions before we hear from Mr. Bright and Sheriff Sills? Okay, Mr. Bright.
Senator Grant's pretty much covered it. I'm totally in favor of this bill. I'll try to be real brief. I think the best way I could explain this is just quickly this case here. About 2 years ago, Miss Baxter's on Lake Sinclair with her family. She, her husband, Mark Baxter, and their daughter is late at night. Intricate boat, driven by Mark Intricate and 3 other occupants, smacks into him, T-bones him head on, kills Mr. Baxter, her husband, right away, throws him in the water. Her daughter screams out, "Help, help, I can't find my father." Even the people in the Intricate boat who were stunned, they said, you need to turn around, we got to help these people. And the defendant, Mark Intricate, and these were his words, not mine, quote, "I can't, I'm on probation, we got to get out of here." And he leaves. We go to trial on it about a year ago, and I had to sit down and explain to Ms. Baxter here why the judge properly granted a directed verdict of acquittal as to homicide by vehicle in the first degree where the underlying offense was hit and run. And the reason for that is because it would not have made a difference. Your husband was killed right away. And her words to me was, "That makes no sense." The words of the Court of Appeals are, quote, "It's nonsensical." And we, the Court of Appeals, call on the legislature. It's not up to us. It's up to y'all, the General Assembly, to change this law. I don't want to mislead this committee. I indicted it 3 different ways: homicide by vehicle in the first degree for homicide by vessel, for hit and run, which is the one that's the one we're trying to correct here. I did get a conviction for homicide by vessel for BUI, boating under the influence, and I also got one for homicide by vessel in the first degree for reckless driving, which are quite candidly 2 charges I came up with later. The original charge was just hit and run, and I foresaw this problem when I drew up that indictment. Bottom line, I indicted it 3 different ways, the same crime. So it didn't affect the ultimate outcome. But again, when I went to it makes no sense. And Ms. Baxter's a good enough victim to work with. Mr. Bright, we need to change this. That's why we're here. I've sent this out on my listserv to my fellow DAs. None were opposed to it. All seem to be in favor of it, that responded to it. I've even been described in the media saying this is a no-brainer. I mean, it's what I call a win-win situation. The simple purpose of this bill is to correct that ridiculousness that you are rewarding a person if you hit and run in a vehicle or a vessel and you kill the victim right away, you're rewarded for it. It's not homicide by vehicle or vessel first degree if the victim died instantaneously. But if you what I call sideswiped them and they did not die an instantaneous death and they lived a couple hours, a day, whatever, and it could have or would have made a difference had you stopped and rendered aid, now you're back to the elevated crime, the 2 to 15 or 3 to 15 homicide by vehicle or vessel in the first degree. The sole purpose of this law is to create, Senator Grant's bill is to correct that nonsense.
Thank you, Mr. Bright. Representative Benfield, is that you?
Just a quick, I just want to pick up on Representative Bearden's point. I think he raises a good issue with the inconsistency. I don't know of any substantive distinction between a hit and run by a boat versus a hit and run by a car. And I guess my question for you is, do you have any arguments for making it 2 years or 3 years for both of them? I mean, I tend to favor more discretion for prosecuting attorneys, so the 2 years would give you the option of pursuing more of a range. I'd just be interested in your feedback on the consistency between those 2.
Right. All right. The laws on vessels mirror the laws on vehicles with that exception. The ceiling is the same, up to 15 years. The floor is just different. 2 years for boats, 3 years for vehicles. We're fine with amending it to make them both 3 to 15. An honest answer, I don't think when I say it would make a difference. We've got enough leeway to work with, 2 to 15 or 3 to 15. I mean, I'm fine with. I think logically, because the bills mirror each other, that they should carry the same punishment, the same floor, the same ceiling, and I would suggest personally just make them both 3 to 15. But as a prosecutor, we like to have leeway, but 2 or 3, either one's more than enough leeway.
Okay. Any further questions of Mr. Bright? If not, we will ask Sheriff Seals to come around if he wants to add anything.
I don't really want to add anything other than echo what they said. It does seem to be senseless that it isn't the same. Fortunately, the sheriff is probably the greatest county in the state, and and have more shoreline than between Lake Sinclair and Lake Oconee than any other non-coastal county in the state, and run patrol boats on both Oconee and Sinclair, and these lakes are becoming ever more crowded, and we're having ever more accidents, and this was a particularly difficult case to solve, and that had not a guilty conscience came forth from one of the passengers on the boat, I don't know that we would ever solve it, and if anything, this could be a deterrent to people staying there to the appropriate authorities. All right.
Okay, thank you, Sheriff. Representative Lunsford.
Thank you, Mr. Chairman. Sheriff Sills, I've just got a question. I'm just curious. Did you notice a higher incidence of hit and run with licensed or unlicensed drivers, or is it about the same, or do you have anything to pull on for that?
I wouldn't say that there's a high incidence with licensed and unlicensed. Alcohol, though, is obviously a big factor, and that was a factor in this case.
Okay, thank you, sir.
The license itself, I don't think, is that big of a factor.
Okay, any further questions of Representative Levitas?
I'm sorry, that was inadvertent. I'm just still waiting on the motion.
Representative Setzler.
Thank you, Mr. Chairman. This is to the author. I have a technical question. I'm just trying to understand different sections of the bill. I think I understand sections 2 through 4. Section 1, where it talks about not just death but injury or death, could you just simply explain to me what that applies to as compared to section 2, 3, and 4? I'm trying to read this language and understand what framework it lies within.
My understanding is, I guess you're actually referring to on page 2, lines 3 through 6.
Yes, sir.
Okay. What I understand, that helps strengthen the directive to actually stop and render aid.
And I suppose my question centers around if there's a duty to stop and render aid, and I'm not attacking this language. I'm just trying to understand why we need to make a distinction about unconscious, appears deceased, or is otherwise unable to communicate with respect to having a duty to stop and give aid. I'm just trying to understand that. I don't know that I have an objection to it, but
when we went to Senator Grant, we were interested in the other sections to fix up our problem, 2, 3, and 4, answering your question, because I was not the one that proposed Section 1, but I think it's a good idea. I think point blank what Section 1 does, I'll do it this way. The change is lines 3 through 6, paragraph 4. Right now, my understanding, that's the case law of the state, not statutory, but it's the case law. I think by passing this, what you'd be doing is codifying, making it the statutory law of the state, which in simple English, if you kill somebody, if your victim in a case, boat or vehicle, is unconscious, appears deceased, or can't communicate, then you've still got to make reasonable efforts to get EMTs out there, law enforcement. I believe that's the statutory, the case law right now, but what you'd be doing here is codifying it. That's the only change that I can think of.
And I asked the question because page 1, lines 25, 26, requires, under current law as I read, requires that a person who causes the accident shall render to any person injured in such accident reasonable assistance, including transportation, making arrangements for transporting, speaks to the issue of medical care. I don't oppose it. I just want to make sure I understand why we're doing it and what it's doing and not doing. It just adds in where a person's injured, a conscious appears deceased, is unable to communicate. It says make every reasonable effort to ensure that emergency medical services. It would seem that you would add emergency medical services in the existing language as opposed to this whole new section. I was wondering if there was something else it's seeking to accomplish. That's my only question.
Mr. Chairman, if I could respond just as a layman, I'm not an attorney and don't even play one on TV, but it does appear that paragraph 3, which is lines 25 and 26 on page 1 and lines 1 and 2 on page 2, speak specifically to an injured person and requesting transport by the injured person, and then lines 3 through 6 take that a little bit further, where someone who's injured and is unconscious, appears deceased, or otherwise unable to communicate, to make sure that, as Mr. Bright said, that the current case law is followed, and someone who is deceased or is unable to communicate is not just left by the roadside unattended.
And Mr. Chairman, that's how I read it. I just want to make sure I understood the intent, because that's what was unclear about that. Thank you, Mr. Chairman.
Thank you, Representative Setzler. Is that Chairman Franklin or Chairman Franklin?
Mr. Chairman, since Section 3 of the bill deals with unborn children, would this be an appropriate bill to attach the language of LC 219910S that was offered to this committee earlier this morning? Would that be germane?
I would like to have had that discussion with you prior to the committee meeting today, Chairman Franklin. I would not rule it. I would rule that it's not germane.
Thank you.
All right. Any further questions? Okay. Sandra Michaels had signed up. Come around.
Thank you, Mr. Chairman. This is language I think I'm the person that Senator Grant was referring to about the language. And I'd showed this to our members that do a lot of motor vehicle work, and they suggested to make it clear on page 2, I'm using LC 350880, in section 2, line 22, adding the words, when such violation is the cause of said death. Their explanation was, and again, this is actually not my area of expertise, on line 22, after first degree, add the words, when such violation is the cause of said death, and again, to echo that language, on page 4, line 2, homicide by vessel in the first degree, when such violation is the cause of said death. Mr. Hawkins noted that that is the element of causation that exists in misdemeanors, so it should also exist in felonies. And the example he used in trying to explain this to me was a person could be speeding and a person runs a red light in response to the speeding, and it causes an accident and the person dies, but the death wasn't from the person speeding. It should have been from an actual collision. So here, I think, the boating part is, I think you want to punish the person for actually causing the death of a person, not just causing an accident, is the meaning behind the words. And I understand, I know I gave this language to Senator Grant, and I understand he has an issue with it.
Mr. Chairman, I believe we've already taken care of this for an example, on page 2 in line 19 and 20, where we actually say causes an accident resulting in the death of another person. So you have that double bar of causing the accident that also results in the death that has to be met before the charge can be brought. So we think that's already taken care of, and there's some concern that when you add the language, when such violation is the cause of said death, that it actually undoes some of the things that we're trying to accomplish in making this hit and run statute deal with both the person who's killed instantly and the person who's killed who dies at a later time.
Did you wish to reply before I recognize the next member of the committee?
Only that I actually had that same discussion with the attorneys, and they said that it's different. So the violation has to be the cause of said death. It can't be just an accident that results in a death. There's got to be an actual causation, and it's a different. The causation that Senator Grant just referred to is a different causation than the causation that the actual violation causes the death. So there can be an accident and somebody dies. For example, someone is following too closely, hits the back tail of the bumper of the car in front of you. Little did you know that person was a very fragile person, and they died. You would want the cause of action to be from the bad spinal problem, not the hitting of the bumper. And without adding those words, it's not clear that the violation's got to be the actual cause of death. And I'm not a PI attorney. Maybe there's some folks here, but they would know better about the aspects of that.
Okay, thank you. Representative Levitas.
Using your example, though, Ms. Michaels, what if you did hit somebody who had a fragile skull, and then you don't call aid because you're concerned about them? If I guess I'm not so concerned with whether or not smashing into them causes the death, but if they are injured as a result of the accident, and for whatever reason that person needs emergency medical aid, and that person makes a conscious decision not to call them, I would want to include that person within the violation of the statute. So I agree with you that it's a different causation, but again, we're not talking about an intent to do an injury here. What we're talking about is somebody who causes an accident and that they violate and it results in an injury for whatever reason, and then they willfully decide not to contact or seek medical attention from this person. So if I'm understanding your amendment, it would require that the accident be of such a nature as is itself to cause injury. And if that's the case, I would ask the committee to vote against this amendment. Can you respond to that?
I'm not sure what you said.
Well, here's what I understood you to say, that you want to make sure that if, for example, you tap the bumper and there's a pre-existing condition, that person who doesn't call for medical attention when this person goes into shock or whatever happens to them, that you would not want to include them within the statute. And what I'm suggesting to you is that if you tap somebody's bumper through a violation of the code and you see that somebody needs medical attention for whatever reason, and you choose not to seek medical attention, which is, I think, the author is saying is the intent of the legislation, I would want to capture somebody within that who makes that decision. So is that your intention?
No, I think if you look at 46270, the scenario you just did is covered under 46270. I think what the statute, the new proposed law, is trying to capture is the boating. I mean, specifically, they're trying to capture the boating, which makes sense. I mean, obviously I have no beef with that. The folks that do this work were just saying that the bill is more clear and stronger if you make it clear the violation is the cause of said death. And if you look at 46-270, I mean, they mention proximate cause, so you would want to carry over that same language into the sections you're
And you don't think that's covered by the words in violation of subsection B of Code Section 40-6-270?
People that do this for a living say no, it's not, specifically.
But what specifically do they say is not captured? Is the proximate cause language in another subsection?
No, it's in the hit and run.
What I'm saying is, you told me to look at 40-6-270, right, and that deals with proximate cause. And what I'm asking you is proximate cause captured in subsection B of that code section? And if
I
it
don't
is,
believe so.
Okay, because if it is, then it would seem to me you'd be covered by that, right?
I wouldn't be saying all this. So their position is it's not there, because here it just says leaves the scene of the act, causes an accident resulting in the death. They're not saying that what their violation was caused it. They're just saying an accident occurred. Their actual violations which should be causing the accident, not just. Okay, so I think I'm beginning to understand. It's not really the nature of the person who's in there, whether it's a minor offense. You're just saying that it's any accident. And is that your problem with it? Is that it could be any accident, whether it's a violation? You get me confused.
Well,
now. Sorry.
I have a habit of doing that. But what I want to make sure that we're not doing is we're not letting somebody off the hook. Because we're sticking in language there that's going to require that the violation itself actually result in the death, as opposed to somebody who willfully violates the statute, regardless of how the accident's caused, and allows somebody to die because they didn't want to bother to call medical attention to the person that needs it.
I think that would already be covered.
Oh, okay. Well, I don't think we're going to come to a meeting of the minds. I'm just trying. I cannot figure out what your amendment is doing that makes it stronger. It seems to me, I think I agree with the sponsor of the bill. It seems to me that we're adding an extra layer of difficulty in proving that in fact the nature of the accident rather than a pre-existing condition caused this. I don't care what the cause is. If they're in an accident and for whatever reason this person needs medical attention, they decide I'm on probation, I'm going to drive away from it, then this is the kind of person I think ought to be captured by this statute, and I'll just leave it at that.
I think the problem with what you're saying, though, is the way you describe is just they're leaving the scene is enough to and they die. That's enough to give them this statute, and I think that's where the problem is.
They cause an accident that results in the death, and it's a violation of subsection B. Those three things required, and if those three things are required, yeah, that's what I'm saying.
But they had to commit a violation before that. I mean, it can't be just leaving the scene. They've had to commit a violation, and they've left the scene, and there's the death of the person. So there's three things here.
I agree.
So that's why you need to modify the leaving the scene, and you need to modify the action.
Okay. Thank you. I have no further questions. Thank you, Mr. Chairman.
I'm sorry. You're not understanding what I'm saying? No,
No, I do. I just don't think we agree. That's all.
Okay.
That's okay. We just don't agree.
Mr. Chairman, if I might add, I do have a copy of 40-6-270B here, and it does begin, if such accident is the proximate cause of death. So, again, I contend that if the person causes an accident that results in the death of another person, and that accident is the proximate cause of death, as stated in 40-6-270B, then we're already covered without this additional language.
Let me, if I could interrupt this discussion just a moment. Jill has come to me with a possible fix. Jill, may I recognize you?
Sure. I think that the problem...
She doesn't have a mic, so let's listen up.
The word resulting on line 20 is the issue, because how it results is really what we're trying to say is it's the proximate cause. So I think if it said any driver of a motor vehicle who, without malice of forethought, causes an accident which is the proximate cause of the death of another person and leaves the scene in violation of, I think that's the link that's the issue. I mean, I didn't work with the author. I don't know, but that's what I'm hearing.
Does anybody have a question about that? Okay. Can you?
Yes, after the word accident on line 19, if you add the words which is the proximate cause of, and strike the words resulting in.
Do you want to stay here?
Mr. Chairman, if the district attorney could respond.
Sure.
Yeah. Ms. Michael's amendment totally defeats the purpose of this bill, and I think your proposal would defeat it too. What your proposal there is when such violation is the cause of death. If going back, when such violation is the cause of said death, if you got a defendant that hits and plows into somebody, motor vehicle, hits and runs, and leaves the scene, and they die instantaneously, that will never be the cause of death. And under Ms. Michael's proposal, I can plug in the facts of the Baxter case, it wouldn't have helped us at all. Actually, I think it's even worse than the present state of the law. And when you make a connection there between, the purpose of this law is when, if I'm a defendant, and I run into somebody in a motor vehicle, and I kill them, I've got to stay at the scene right there, whether they die instantaneously or they die a slow death. If I leave the scene of the accident and I don't stop and render aid, if I leave the scene under present law, if they die instantaneously, I get off the hook for homicide by vehicle or vessel first degree. Both their proposals defeat our whole purpose of why we're here. I'll go back to the
We've got number of discussions breaking out all around the table here. If I could ask you to, let's come back to order. I'm going to go back and recognize Representative Levitas, who got us all in this.
But with all due respect, Mr. Chairman, I didn't propose this substitute language. I would ask Attorney Bright for his comments. You heard my line of questioning, and my understanding of what you're trying to do specifically with the new language on page 2, lines 3 through 6, is if somebody's unconscious and you're involved in an accident, it doesn't matter why they're unconscious, you want somebody to go get medical attention so that person doesn't die. And if we add this language, we're going to defeat the entire purpose of that provision. Am I misunderstanding something?
Exactly correct.
Okay. Thank you, Mr. Chairman.
Got several lights now. Chairman Knox, you had yours on for a while.
Let me see if I understand. I think maybe we're confusing the matter by using the term proximate cause. That's really a tort term. I think what we're trying to get at is saying that where the cause of death is caused by the accident. And the scenario I'm talking about is that if a person dies of some intervening cause, like the person is transported to the hospital, whether or not whoever got them there doesn't, if they're transported to the hospital and there's some sort of medical malpractice that results in the death of the person. But the only reason they're there is because they had this accident. But the person leaving didn't have anything to do with this, and the accident itself didn't have anything to do with the person dying, because the person been all right, other than the fact that they had the wrong blood transfusion or something like that. That's the issue I think we're trying to get at here. What we're trying to say is, if the accident causes the death, that's the cause of the death, not something else that may happen. Resulting means anything could happen after the accident. They could have a wreck in an ambulance on the way to the hospital and die as a result of the accident. So what we're trying to get at this perpetrator who left the scene and who had the accident. That's who we're trying to get at. We ought to limit it to that. And in the situation that you're talking about, but the underlying accident has to have been the cause, because otherwise it doesn't make any difference whether they stayed at the scene or didn't stay at the scene, because the person died from something not even related to the accident that occurred. You follow me?
I do.
Okay. So I think if we left out the language, Mr. Chairman, if we left out the language proximate cause and just said caused by the accident, you follow me, Jill? I think that would probably get to what you're trying to get at, and it would preserve the requirement of making sure that person stays there and renders aid, and that if they fail to do that and the person dies as a result of that accident and the fact that they didn't render aid, then you've got a case for them.
Okay, here's where we are. Got a lot of lights flashing. I think what we're going to do is we had planned to take a lunch break today. We're going to go ahead and do that, and hopefully that will give time for this discussion to continue, perhaps resolve. And if not, at least put us in a situation where we can go ahead and vote. We've got one other bill on the agenda after this, so it is now about 12:14. Let's break till, say, 1 o'clock, and then we'll meet back in here. 1 o'clock we'll reconvene. And if those of you who have your lights flashing still have questions, we will take those up at that time. Members of We have come up with something that addresses Chairman Knox's concerns, and on page 2, line 20, we recommend striking the two words "resulting in" and replacing them with "which causes," and do that again on page 3, line 35. Again, strike "resulting in" and replace it with "which causes." Again, I believe that the amendment that Mrs. Michaels was bringing forth would defeat the purpose of the bill, and we think this change clarifies the scenario that Chairman Knox brought up, and with that we'll just put it in the hands of the committee. Okay, thank you very much. And what I will do is when we get to that point, if there's a motion to if the committee wants to move forward on the bill, then I'm going to hopefully have one of the committee members offer that as a friendly amendment. Any questions about the amendment? Any questions? Ms. Michaels, you were sort of at the podium when we took the break. Do you wish to come back and you got anything?
No, I think that's about the best I'm hoping for. Doesn't sound very nice, but thank you. I don't think I'm going to win as well. But thank you for that one. I think it'll ameliorate some of the problem.
You're having one of those days too, huh? Okay. All right. Thank you very much. All right. Any further questions? I think there was no one else that had. Was there somebody else? She did. Yeah. I don't think anyone else had signed up. Anyone else want to be heard on this? Okay. We've got lights flashing now. Representative Levitas.
I have an amendment if it's the appropriate time, Mr. Chairman.
Let's get a motion first.
I have a motion to do pass.
Okay. Okay. We have a motion that Senate Bill 529 be given a due pass recommendation. Recognize you again, Representative Levitas.
Mr. Chairman, I have an amendment, and this
is this the amendment that the author has requested?
Not yet, sir.
Okay.
But I'll be happy to, if you want to take that one up, I'll make that part of this motion, if you would like.
Why don't you do that?
Okay. I would move that beginning on page 2, line 20, the words "resulting in" be struck and replaced with "which causes." And there is also, that's on page 3 at line 35, same change.
Okay.
Though I still have my reservations, since the author and everybody seems to be on page, I'll make that motion on their behalf.
All right. And there's a second to that. Is there any objection to that amendment? Any objection to the Levitas amendment? Hearing none, that amendment will stand adopted. Did you wish to be recognized further, or
yes,
shall
sir.
I go to Secretary Bearden?
I think this is pick up on Representative Bearden and I, Secretary Bearden and I have talked, and I'll be making his motion as part of my motion.
Can he not make his own?
He's not really up to it.
Okay.
I told him that that the chair would want somebody in a tie to be making these motions, so that's why I offered to do it.
In that case, I'll speak on my own.
But let the record reflect, Senator, he's not wearing blue jeans.
Duly noted.
Whether he's armed or not, we don't know.
And we don't ask. Okay, Representative Levitas.
I wasn't familiar with that "don't ask, don't tell" policy, but Mr. Chairman, I would make the second motion is beginning on page 3 at line 15, strike the word "to" and replace it with the word "3." On line 30, this is in the unborn child provision section. Then line 32, same page, strike the word "to," replace it with the word "3," and finally on page 4 at line 3, strike the word "to" and replace it with the word "3." And I'll have one more motion after that.
Is there a second to that motion?
I'll second my motion.
Okay. Is there any discussion? Is there any objection to that amendment? Hearing none, that amendment stands adopted. Representative Setzler.
The changing that to 3, I certainly have no objections to that. Are there other parts of the code that would still say 2, or will this completely clean up the code with respect to this homicide by vessel?
I think to my knowledge, it completely cleans up the code.
Okay. Do you agree, Jill?
Mr. Chairman, I've got a true housekeeping amendment we could handle maybe while council is looking at that, if it pleases the chair.
Mr. Chair?
Representative Setzler.
I was just prepared to either have Representative Levitas add another code section to his amendment, or at least put that before the committee if for cleanup purposes, so we can be consistent across the board. I think that's the will of the committee.
You've raised a good question, and if we could, let's suspend consideration of that till Jill finishes her little homework here, and I'll come back to you. We need to resolve that. Do you still want to be recognized?
No.
Okay. Okay. All right. For Levitas, is this amendment
This is Levitas
3 or
3,
4?
although I would call this the Travis Amendment. She's very familiar with my particular pet peeve in the code, and I'm working slowly on my code revisions. This is simply a grammatical correction throughout this code section, and it begins on page 2 at line 17. Strike the word less and insert the word fewer. On line 22, at the end of that line, strike the word less and insert the word fewer. Same on line 34 at page 2. Moving on to page 3, strike the word less at line 15, put in the word fewer. Line 32 on page 3, strike the word less, put in the word fewer. And finally, on page 4, line 3, strike the word less and insert the word fewer. Just a grammatical cleanup.
Do I hear a second to that?
Representative Bearden promised me, so I'm expecting that momentarily.
We have a motion on the third Levitas amendment. Is there objection? Is there objection? Representative Abrams.
So I'll withdraw my amendment so that we can move forward on the bill.
I wish I would never seconded it.
Okay. Further discussion? Further discussion? Jill, before I call the question here, did we resolve Representative Setzler's concern?
Can I ask a question of Mr. Bright?
Sure.
No, it doesn't address feet aside by vehicle either.
Yes, it does on section 3.
Okay, you're right.
This bill cleans up feet aside by vehicle, but not by vessel, right?
Yes, yeah, I'm trying to see. Yeah, you're going to need to.
You want to clean up the feet aside by vessel too.
Yeah, shouldn't it say
the same thing
as
applies.
provided in subsection A or B
Yeah.
of 57?
Yeah, it should. It should.
Right.
Okay.
What do we got?
Section 52-7-12-3, which isn't contained in this document, which is entitled feet aside by vessel, and it takes up the same language. It practically mirrors
Section 3.
40-6-393.1, which is the feet aside by vehicle, section 3 of the bill. And you'll see that all that you have done in that section 3 is add in the other first degree penalty, and you need to do the same thing in 52-7-12.3. So you need to add that new code section in, mirror it, and then also change the 2, which was Representative Setzler's issue, to 3.
Representative Setzler.
I would offer what she said is the Setzler amendment.
I'm glad somebody else got one in there. Okay. Any questions about the amendment before I ask if there is a second? Any questions?
Again, Mr. Chairman, for purposes of making the code consistent.
Thank you. Is there a second to the Setzler amendment? Okay. Is there objection to the Setzler amendment? Any objection? Hearing none, that amendment stands adopted. Chairman Franklin.
I'd still like to know, since we just did yet another feet-aside amendment, I would like to offer the language that was offered earlier as an amendment, since it deals with the same subject.
And the chair will rule the same, Chairman Franklin. Okay. Any further discussion? Any further amendments? Any further amendments? All right, we're back to the main question, which is the motion to give Senate Bill 529 a due pass recommendation. Any further discussion on that motion? Hearing none, all in favor of the motion, please indicate by raising your right hands. All opposed? Motion carries. Thank you very much, Senator Grant, for being with us.
Chairman, I appreciate the courtesy, and thank you, members of the committee.
Always a pleasure having you here. Okay, the next bill. What happened here? There we go. The next bill we have is Senate Bill 249, and this was a bill that was sponsored last session by former Senator Whitehead, and Vice Chairman Mumford is carrying it on the House now. And so I recognize Vice Chairman Mumford, who I understand has another commitment at 2 p.m., so we're going to have to consider this one fairly quickly. Vice Chairman Mumford.
Thank you very much. I'll bring you the substitute to Senate Bill 249. I have it as LC 293424S. This is the Sheriff's Association's request for changes to the Sexual Offender Registration Review Board statute. In Section 1, it would establish that homelessness or a vehicle cannot be considered as the sex offender's address. In Section 2, it would establish that sex offenders cannot reside within 1,000 feet of daycare centers licensed by the state of Georgia. Daycare centers would include licensed family and group daycare. 3 would require multiple county registration whenever the sex offender works or attends school outside his or her county residence. 4 requires the sex offender to provide a change of address or information to the sheriff of the county to which the offender plans to move 72 hours prior to moving. 5 requires that the Georgia Department of Corrections notify sheriffs 15 days prior to the release of sex offenders. 6 eliminates the annual $250 registration fee for sex offenders. 7 eliminates the requirements that sex offenders must register while incarcerated. 8 provides that the registry and subsequent updates by the sheriff can be provided electronically at locations where there is a requirement to post a list or registry of sex offenders. 9 establishes that a sex offender cannot loiter within 1,000 feet of restricted areas, including churches. 10 provides that medically, physically incapacitated sex offenders residing in hospice facilities, skilled nursing homes, residential care facilities, or nursing homes can be removed from the registry upon an order of the Superior Court. On that particular provision, I have a constituent of mine whose father was in a Veterans Administration nursing home, had already been forced to move by a previous enactment of the sex offender law, and after the last enactment, he was in violation, even though he was incapacitated in a hospital bed at a VA facility. Number 11 prohibits sex offenders from volunteering or working within 1,000 feet of a child care facility, school, or church. Number 12 establishes that distances from restricted areas shall be measured from the address of the individual's employer or volunteer location. Oh, okay, sorry. Thank you very much. I'm being advised that some of this is not there. Let me get back here. And I've gone through most of it. I may not have given you correct information on all of it. I would ask Terry Norris to come forward and he can answer any questions that you have about this bill. No problem.
But Mumford, none of this bill would delete any of the provisions of House Bill 908 that we passed earlier this session, would it?
That's what I'm advised.
Okay, just wanted to be sure. Mr. Norris, and you got Sheriff Sills with you, and we're pleased to have him. He's putting in a good full day with us today. Can I go with you? Who's first?
Well, Mr. Chairman, I think Mr. Mumford has provided the overview that we asked him to do. For clarification, these were not by sections. These were just general summaries of the changes. To answer your question, absolutely not. Doesn't touch anything that 908 provided for. It is a sort of pared down version of the original 249. I guess from our perspective, if you all recall from the previous conversation, I mentioned that in the aftermath of the sex offender registry changes of 2 years ago, we brought forth, identified about 300 deputy sheriffs and other personnel from sheriff's offices throughout the state that are responsible for the function of monitoring and tracking the movement of sex offenders, registering, monitoring, and tracking sex offenders. And these 300 people, there is a representative group of that 300. It's our Sex Offender Registry Task Force. It's by regions of the state, and the task force members are responsible for receiving information for those individuals in that region that have concerns about the manner in which the current law was to be applied. So what you have on this page in the 249 are not sort of, but the issues that our resident experts brought forth to us. We don't see the provisions of SB 49 and this substitute to do anything but strengthen the sheriff's ability to provide the service that this General Assembly asked and the governor asked us to provide a couple of years ago. With that, Mr. Chairman, I have Sheriff Sills here, who I am told doesn't have that many sex offenders living in Putnam County for some reason. I'm not sure exactly why, but y'all might figure it out yourself. But with that, Mr. Chairman, I appreciate the consideration of the bill. Be glad to answer any questions.
Well, the chair was going to ask why, and since I don't know the answer, I'm not going to, though. But I am going to recognize Representative Levitas.
Thank you, Mr. Chairman. And first of all, I want to say it again. I want to appreciate the work I've had the opportunity to do with Mr. Norris. He's been a terrific person to work with, not just on this bill and on my bill, but on others. And what I want to try and arrive at through this line of questioning is maybe what we need to do to get around some of these problems. It doesn't tax county resources. We have a great tendency here to pass down unfunded mandates to the counties. And in fact, I'm trying to get a study committee to address that very subject. So what I don't want to do is pass out here more stuff to make you guys do more because we say to and have counties pick up the tab. That said, I'm a little concerned with a couple of provisions. And I want to start with Section 4 of the bill on page 3. My concern with this, and I'm actually asked judiciary staff to help me with this, I seem to remember an anecdote of an individual who was not required to be listed on the sexual offender registry, who was released from prison, there was no alert sent out to the local authorities, and that person went out and committed another offense. My concern with releasing somebody from the registry requirements are, while they're incarcerated, is just that. If we don't have track of them, the reoffense possibility, especially with serious sexual predators, is a problem. So my question is there a way that we can continue to track them to relieve the burden on you? And I'm asking for your help on how we would do this. Do we need the GBI to become involved to help take it off of the sheriffs? But my grave concern is not keeping track of sexual offenders merely because they're incarcerated when they get released from prison, not picking them up. How can we keep them registered so that we know who they are, where they are, without burdening sheriffs and county tax dollars?
Vice Chairman Mumford.
If I might respond to that, I mean, I think that part of the situation is that there's requirements that these people present themselves to the sheriff and affirmatively register, pay the fees, that sort of thing. Clearly, if you're incarcerated, it was absolutely impossible for you to do that when the previous bill was passed. This is simply trying to recognize the fact that if you're incarcerated, theoretically the state knows where you are. I agree with your concern about people being released, but this requires notification, and clearly things cannot be done as they should be done that could result in a problem. But I think that the requirement here that the notification
doesn't address that. Okay, then if I can move on, Mr. Chairman, I'll accept the Vice Chairman's representations. My second area of concern is with the new section on Section 9, and I understand what this is trying to address. My concern is that I'm not sure it's targeted enough, and by that I mean I don't have any problem with somebody who can't move out of the hospice area, who's not otherwise around anybody who could be a victim, but I'm wondering if alcoholism, for example, and I'm trying to look up the code section as we speak, whether that would count as a permanent disability under 49-480. And if somebody, unless they can't move about, and I have all the sympathy in the world for anybody that's in a hospice situation, but there are all levels of hospice. You can be sent home or sent to hospice with many, many months left to live and have a very serious sexual predator history, but this would release you from those registry requirements while you're still able to get around. And theoretically, especially if you're somebody who's not able to be cured and you know that you're terminal, you almost have nothing left to lose. And I'm concerned that just because someone's at a hospital facility, or just because they're at a hospice facility, or just at a skilled nursing home, that they are not capable of reoffending. And I hate to release somebody, no matter what their situation is, who's a serious sexual predator, if they're capable of reoffending. And I guess that's my concern with it. And again, I want to be clear, I'm not about trying to create any extra burdens, but I'm much more concerned with protecting the victims from the public from people like this. To anybody.
Yeah, well, first of all, this requires a judge, a Superior Court judge, to authorize this, number one. It's not an automatic thing. And it exempts them from the residency requirement.
I understand that, but I mean the residency requirements are there for a reason. And Judge McGarrity's not here today, is he? So I won't get in trouble. Oh, he is. All right. Well, I better be careful what I say about Superior Court judges. Then, thank you, Judge. Good to see you as always.
I'm just saying, that we don't have a problem. We would hope that our courts, in their wisdom, would make sufficient inquiry as to whether or not it was just some drunk that was claiming to be disabled, as opposed to someone who was, in fact, truly disabled.
And Judge McGarrity is different because he is one of the shining stars, but there are a few who don't rise to the level of Judge McGarrity, and I am genuinely concerned that inquiry may not be made. And so my suggestion is one of two possibilities: to either more narrowly tailor this so that even if the judge is making a finding, it has to be based on a certain set of criteria such that they cannot otherwise get around, or that the judge issuing that order make a written finding that the public safety is not put in jeopardy and that the interests of justice are served by that, and it would just be a written finding that that judge who has to stand for re-election would make, specifically finding that there is no risk to the public safety and that it serves the interest of justice to release the individual from this particular requirement. Would that be acceptable to the author and to the sheriffs?
How about if we were on line 7 after the word court to insert the words in writing? The court in writing finds by preponderance of the evidence the individual does not pose a substantial risk of perpetrating any future dangerous sexual offense and the individual.
I think that would work for me. Is that acceptable to the author and to the sheriffs? Okay.
Acceptable to me.
Then at the appropriate time I'd make that amendment.
Thank you, Representative Levitas. Representative Abrams, and then Chairman Knox.
I just had a more technical question. Going back to, and I know this is the current state of the law, I just want to know what happens. On page 1, under subsection 1, what happens with a person who's separated or who is homeless? What are the actual requirements for compliance with the law?
Technically now they're in violation of the provisions of the Act.
So what happens?
They are charged with failure to register and given a mandatory 10 years in the penitentiary, if I'm not mistaken. I've actually seen that happen in Rockdale Superior Court recently.
No. Chairman Knox.
Mr. Chairman, thank you. Let me ask you on Section 4. Is this a directive to the Department of Corrections, this new language? I'm thinking it is.
It's Section 4 on page 3.
Yes, sir.
And the question is this a directive to the Department of Corrections?
Right.
That's what we think it is, yes, sir.
Okay. That being the case, how is it that we can make them send that information if a person's maxing out, for instance, even if they're going to be on the sexual offender registry? If they're maxing out, they don't have to tell the prison or Department of Corrections where they're going to live until the day they're walking out the door. So how can we require DOC to tell them 30 days ahead of time where the guy's going to be living if the person doesn't have to tell them where he's going to be living? He may not know. If you've been in prison for 20 years, you might not know where you're going to live real quick.
I'm not sure that I can answer that because I'm not entirely familiar with how the Department of Correction operates. I was under the impression that every time someone was released that they had some address that they were released to. Now, you may be right. If you've maxed out, there may not be that requirement.
I don't think, particularly, and I'm thinking in a case particularly where they've maxed out, they're just going to give them a bus ticket, and they don't have to tell them jack about where they're going, other than the fact that they're going to be on the sexual offender registry. They don't have to tell the prison that, or wherever they're being released from, but they have to notify the county where they're going to be living within. This is on the offender now. Even if he's been released and maxed out, he still has to tell, or she has to still tell the county where they're going to be living within 72 hours that they're living there, not where they're going to be living, but that they are living there in place that they're residing within 72 hours. They're supposed to be residing. The theory under the law is that you're going to be residing someplace in 72 hours, and it's not going to be a car,
I wouldn't suggest
under a bridge.
The state of the current law would create absurdities, but I could see a situation where if you refuse to tell them where you're residing, then the minute you step out of the prison, they could arrest you for being an unregistered sex offender.
I'm not sure you would be unregistered at that point. You got 72 hours to tell them where you're going to live.
Yeah.
So you're not unregistered. You're a registered sex offender. You just haven't told them where you're going to live yet. That's the issue. You don't have 72 hours to be registered. You are registered when you leave there because they're going to register you. But when you leave there, whether if it's a max out or a probation or parole, whatever, you have to give them an address, but you don't have to give them that address, as far as I know, until you're walking out the door.
You do on everything but the max outs. When you're under parole, that's one of your conditions of release. That you're going where you're going to live, where you're going to work, etc.
Yeah, I understand, but I don't think you don't have to tell them that until you're ready to go out the door where you're going to. I mean, when your release date comes up, you're released. They're going parole case, even on if it's a split sentence, you're going out on being released and you're going to be on probation. You don't have to tell them where you're going to be living until the day you're walking out the door, or maybe the day before if you want to be a nice guy. But other than that, I don't think there's anything they can do to make you tell them where you're going to live. You just, until you're going out of the prison, they can tell you now where you going. They have to tell you that, but they don't have to do that until because they may not know. I mean, they may still be trying to work it up with mama or their brother-in-law where they're going to live.
Could we suggest in those particular cases where it's a max out and the Department of Corrections doesn't know, change the language where they would notify us in those cases?
Is there anybody here from the Department, Mr. Chairman? Is there anybody here from the Department of Corrections? Maybe they can tell us what their. I'm just curious. Regardless of what their practice is, I don't think we can force them with this law to tell the sheriff's department of the county where the person is going to live 30 days ahead of time where they're going to live if they're not required to say 30 days ahead of time where they're going to live. They don't have to tell the Department of Corrections that, or the warden or whoever it is that they're making up their paperwork with.
To answer your question, I don't think there is anyone here from the department.
That's not unusual.
If I may, one last point.
Sure.
On that point, again, the only people that I presume the chairman is speaking of are the discharged max outs. Is that correct?
I don't know that for a fact. What I'm saying.
I do. You cannot get out of prison on parole if you don't give them.
That's not my point. Is not that you can't get out of prison. I know you can get out of prison on parole, and you've got to tell them that you're going to go somewhere, but you don't have to tell them 30 days ahead of time where you're going to be. They just don't have to open the door and let you out until you tell them where you're going, even on probation or parole.
But it is a huge incentive for the offender wanting clemency to find an acceptable place of residence, which gives the parole board the opportunity to check that residence out and make sure it's suitable. And I do know that for a fact. So I think, honestly, that there is a group of people that we are talking about, and I think that group is going to be your max-out cases. You're right, exactly on that. But I don't think the parole board is going to let many people out of prison until they've had time to review that residency plan.
Representative Everson.
Yes, Chairman Munford, on line 7, page 4, what's the thought behind the removal of the annual registration fee?
Many of these people are unable to hold jobs because they cannot work in a variety of locations. They are not, I think the experience that the sheriffs are having is that they are highly unable to pay the fee. There's vast inability to pay. The requirement of the fee also has a counter, as you know, as a former probation officer. It has the pressure to bring in the money to pay the fee is having a counter effect in that people sometimes would not come in because they don't have the fee. So, and I think we're trying to encourage them to come in and register. That's the goal here, and that's the reason. This is a provision that has not been developed because we don't want to collect the $250. This is trying to, I guess, react to the realistic situation that's on the ground as far as trying to collect this fee. And we think it's a lot more important to have these people coming in to register than collecting the fee.
Follow up. Thank you, but wouldn't you agree, back to Representative Levitus's comment about unfunded mandate, that some form of a fee would help offset the cost of operation of the registration process?
I would tell you
for the sheriff department.
Maybe Mr. Norris should speak to this. I have limited statewide knowledge of what is going on, but I would tell you that A, the $250 fee does not cover the sheriff's costs. B, the time and energy that the sheriff spends, as you know, being a former probation officer, trying to collect a fee which cannot be collected is an unfunded mandate. And finally, the fee is having the a result of discouraging people from registering. They're concerned that they don't have their fee and that they're going to be in trouble. So it's really just a loser on the way I see it on 3 levels.
Well, as a former probation officer, and I still stay in contact with the probation officers, we do work with those individuals to make sure that even if the agreed amount is not able to be paid by the probationer, we work with them so they can pay something to the court system.
The way this is written, the sheriffs don't have that, have that flexibility, do they?
If I may add, this fee that is sometimes but rarely collected doesn't go local. It doesn't stay locally anyway. It comes to the state treasury. So there was never any of the proceeds that may have come from the fee would have never helped offset the cost of providing the service at the local level.
Right. Thank you.
Representative Setzler.
Thank you, Mr. Chairman. In the spirit of this, and I know a lot of this is cleanup language to try to clean up where we are, I'm going to offer just to the author, just for purposes of policy, getting back to the questions outlined in Section 4. It would seem, again, Section 4, page 3, listening to some of the discussion over the last 15 minutes, it would seem that if 15 days prior to release or placement on parole, as the language outlines, or 3 days, business days after a sex offender is placed on probation, it would seem that if the information is going to be provided to the county, the sex offender would have to provide to the system their fingerprints and photograph, which presumably would already have been rendered, but and then the sex offender's address. I mean, are we not, isn't it true that we'd be requiring the sex offender to establish where he or she is going to live 15 days out? And if that's the case, should we not just hard code that into the language to require they disclose where they're going to live 15 days prior to release, so that can then be provided to the sheriff? I mean, I don't think that was the initial intent of this, but I think it's the implied effect, or by implication, it's the effect of what we're doing.
All right, let me ask you a question to try and respond to you. You're up here in Section 4, basically lines 4 through 12. Is that where you're looking?
I am.
All right. That is a requirement, as I understand it, and Jill can correct me if I'm going to misstate this, for the Department of Corrections. Mm-hmm. So, meeting some of the discussion that we've previously had with Chairman Knox, what it actually says is that, as I understand this, the Department of Corrections is required 15 days prior to release, and that's release from prison, which I think would capture people who are maxed out. Mm-hmm. Placement on parole, supervised release, or 3 business days after a sexual offender's placement on probation, the following information shall be forwarded to the sheriff's office. That's not forwarded by the sex offender. That's forwarded by the Department of Corrections. I understand, Jerry. Okay. And my question was, and I'm just suggesting potential language to outline what I'm considering is, on line 7, or starting on line 6, the following information shall be, I would consider inserting, provided by the sexual offender and forwarded to the sheriff's office of the county where the sexual offender is going to reside. Make the sex offender in statute specify where he or she is going to live, so that can then in turn be provided to the sheriff's office. I mean, I think that's an implied requirement as Section 4 is currently phrased, but I think if we specify it as a requirement, there's no question about whether the sex offender would have to have the burden of establishing a residence, or whether that's silent and the sex offender could say, well, I'm going to contend I don't have to provide this until the day before I leave, and then we get in a situation where the sheriff's office doesn't find out until the day is released. I would almost rather hard code into the language the sex offender would have to provide establish a residence, so that could then in turn be provided. Otherwise, I think we'd find ourselves in a situation where that wasn't done and sheriff's offices weren't being notified 15 days out because there's no statutory requirement for any resident to have been established. Well, actually, if you look under Section 5, and it's just been pointed out to me by learned counsel, page 16, line 17, rather, does require the offender to provide required registration information to the appropriate official before being released from prison or placed on parole, supervised release, or probation. So I think that's going to cover your issue. I mean, as I would read line 16, that would say it's
they shall provide the information. I'm sorry, line 17 and 18. There's a requirement to provide that. Are we, as a matter of public policy, suggesting that it ought to be done 15 days out so the sheriff's office could be notified?
I think they basically are required to provide it upon request, would be my interpretation. I don't really see how a person in prison is going to, I mean, I guess they could, yeah, it says before being released, but I mean, you know, I guess the question is where are you going to live is the only real issue here. And, you know, I'm sure there's a lot of them that say, I have no idea. I don't know.
And my concern is if they say, I have no idea, and they get out and they're wandering around and they've not been required to establish this, that's precisely why people are falling through the cracks right now, because they don't have mom's address to go back to.
But, I mean, clearly if you're required to register and you can't be homeless, as we've already established, then you go back to prison for 10 years, I think is the solution, isn't it?
And again, to that point, I don't want the cure to be worse than the disease, but I mean, I think we need to discuss if we're going to hold the system, the Department of Corrections, accountable to provide something. And I support the public policy that's important to provide. Then we ought to have a corresponding burden on the offender to establish. And if the offender doesn't have to establish 15 days out, then we ought not hold the Department of Corrections responsible for providing that. I think what we do just needs to be internally consistent. I'm not trying to make this hard, but
if I may, the Department of Corrections cannot provide what they do not have. There's been times that they couldn't provide that address. I do know for a fact that on max-out cases that there has been at least one horrendous case where there was a person that was basically mentally retarded, had served all of his sentence, was released, had no where to be released to, was sent to, because of the hard work of the counselors at the prison, they found a shelter in Rockdale County, Georgia. They sent this person to Rockdale County, Georgia, who had never been to Rockdale County, Georgia. So they established that information themselves.
Correct.
So that's kind of the reality of how that happens. Once that guy got to Rockdale County, the shelter that he was sent to was within 1,000 feet of the school. Well, when our investigators in Rockdale County looked at it, they found that to be true. This man had no relatives anywhere. He stayed 3 days in the lobby of the Rockdale County Jail. The deputies fed him and took care of him for 3 days until they could figure out where he could live. They found him, the deputies actually found him a shelter in Atlanta that would take him. So the reality is they don't always know, but they cannot provide what they do not have.
And the school was about 995 feet away, wasn't it? Well, I know where the facility is, and I know where the school is.
Well, and again, I'm not trying to make this thing more complicated. I suppose that, to your point, Mr. Norris, I mean, the fact that it's hard to make these arrangements that ought not be done, in the last in the last business day of this process.
Let him handle it because I got to go up there. Thanks. Yeah, he can.
Give him authority to deal with amendments.
Do whatever he wants to do with it.
I'm not sure that that's exactly what Mr. Norris wanted to hear.
I must admit, I'm having more fun with this bill than almost any bill I've had this year.
Well, I hate that you have to leave during the middle of it.
And Mr. Chairman, I mean, again, it just seems to me that if our public policy intent is to make sure that before offenders are released, information is provided to sheriffs so they can pick them up on their radar, and they know where they are, and that adequate arrangements are made so that the circumstance you just described does not happen. It would seem trying to do this in the last business day or the last 2 business days before they're released is just a recipe for finding out the afternoon after we let them go, oh my gosh, this place is within 1,000 feet of a school. That wasn't the right place. It would seem that making these arrangements 2 weeks out would give the system time to make sure this is done and make sure that folks are released in a deliberate, controlled way where they're picked up on the radar of the receiving sheriff and things don't fall through the cracks. So I believe that to be consistent, if we think 15 days is important,
then we need to establish a planned residence 15 days in advance so that the whole system can work like we want it to. And I'd be interested in the thoughts of the members of the committee, but I think I'm prepared to offer an amendment to that effect, Mr. Chairman.
I'll recognize you later for that purpose. Chairman Knox.
I'm trying to find in the bill. In the summary, it says something about the Sexual Offender Review Board being able to close meetings on some grounds, and I can't find that in this bill. Was that in the previous version of this, or?
Yes, sir, it must have been.
It's not in here anywhere. Okay.
Okay, any further questions? Further questions for Mr. Norris or Sheriff Seal? What's the pleasure of the committee? I'm sorry, you did. Thank you. And I had that in front of me, and it got covered up with papers. Sarah Garrity?
Yes, sir.
Is that, did I mangle the last name?
Not at all. You got it just right.
Well, good.
Thank you, Mr. Chairman and members of the committee. My name is Sarah Garrity from the Law Office of the Southern Center for Human Rights. We represent a class of everyone on Georgia's sex offender registry in a challenge to Georgia's sex offender residency and employment restrictions. And I'd like to speak in favor of Section 9 of the substitute. And this, again, is the section that would allow for the possibility of an exemption to the residency requirements for certain people who are incapacitated and in nursing homes. And I just want to make it very clear that it's the possibility of an exemption from just the residency requirements, that is the 1,000-foot requirements, so that this does not provide for release from registration for anyone on the registry. It just applies to the 1,000-foot residency requirements. In the context of our litigation, I had occasion to visit a nursing home last year where there were 3 people on the registry, one of whom had a number of strokes and was confined to a wheelchair, another of whom had a debilitating brain disease and basically sat in a chair and rocked back and forth all day, could not walk or talk, and the third of whom was in hospice care with less than 2 months to live. I was there because the sheriff's office had sent called the nursing home to say that those people would have to leave the nursing home. It didn't matter that none of them could get up and walk across the room, let alone 1,000 feet or about a fifth of a mile to the church that they were in proximity to. The law did not have any exception for them. I also represent an 82-year-old person in Houston County who has advanced Alzheimer's disease. He lives at home and is cared for by his 80-year-old wife. They were also served with a notice that they would have to leave their residence because it was within 1,000 feet of a church. I talked to the sheriff's deputy who was supervising this case. She sure didn't want to make this person leave, but the law left no opportunity to have that not be the case. No exemptions of any kind under the current law. I find that most of the people who are in this sort of situation often have limited resources, and in some cases there may be no other option for where they can live other than the jail. We now have a lifetime registration requirement, meaning that there will be many people on the registry well into their 80s and 90s, and these are people who at some point don't pose a danger. So I think it would make good sense to have some kind of mechanism to permit their release from the residency requirement. And I think that without this change, the law is very much vulnerable to a substantive due process challenge of the kind that we're bringing right now. And I don't mind saying with my esteemed opposing counsel, I think Ms. Westmoreland is still here, that if you incorporate this language into the law, it will go a long way to take the steam out of the lawsuit that we have right now. So I wanted to speak in support of that. I do have one concern with the substitute, and that is in Section 1. Representative Abrams addressed it a moment ago. It has to do with the homeless provision. Under the current code, the sex offenders are required to report certain required registration information, including an address. And in paragraph 1, the clause says, being homeless or living in a vehicle shall not constitute an address. I think the purpose behind that was a good purpose. It was to prevent offenders from using the term homeless as an address, which is, of course, a bad idea. The purpose of the registry is to keep track of known offenders and know where they are. The problem with the way this legislation is being is the way that the legislation is being interpreted. It's being interpreted to require the arrest, as Representative Mumford said, of people who are homeless. I think we can all see that there is a pretty big constitutional problem with arresting people based upon their status as a homeless individual. And I think, in fact, the Supreme Court is going to agree with that. The Supreme Court just granted cert a couple weeks ago in a case interpreting this homeless provision. We have drafted some proposed language. If I may, thank you. Hand it out. That I hope will, for the committee's consideration, that I hope will balance the interest between keeping track of known offenders and not subjecting them to 10 to 30 years of imprisonment if they are in fact homeless. And it would do that by requiring that a sexual offender who's homeless and doesn't have an actual residence address would be able to provide an address, a specific location where he or she frequently sleeps, including but not limited to the nearest intersection. And it includes a requirement that the person must report on a weekly basis. The language is modeled in part after an interpretation of the law provided by the Attorney General's office. Because I think that they are, although I hesitate to put words in their mouth, but I think that attorneys could all pretty much agree that you just can't make it illegal for someone to be homeless. And that is the way the law is being interpreted. I've gone to the Fulton County Sheriff's Office myself with a homeless person and had the deputy tell me if he does not have an address, if he is homeless, I need to arrest him, so you all better find him an address. So I had the same issue come up in Cobb County, where I represented someone who was prosecuted for being homeless in Cobb County. So we would respectfully ask the committee to consider the amended language to Section 1. Thanks.
Any questions? Thank you very much. Thank you again, Sarah, for reminding me. Okay. Any questions or comments, any discussion from the committee? What's the pleasure of the committee? Okay, we have a motion that Senate Bill 249 be given a due pass recommendation by committee sub. Discussion on the motion, Representative Benfield. A good time.
I would move that we pass the amendment that was distributed by Ms. McGarity. What page? Page 1. Page 1. Lines 21 through 23. Lines 21 through 23. Let's see. Cross out "and being homeless," the remainder of that section, and then replaced with the language that's been distributed to us.
Okay.
And I'm happy to discuss, but I think she did a pretty good job of explaining. I've talked with Mr. Norris. I understand the sheriffs have concerns. It's just a difficult situation with the homeless, and I certainly don't want to see folks caught up, being rearrested purely for being homeless, and there certainly are some legal problems with arresting folks purely on the status of being homeless. So I move that we adopt this language.
Is there a second?
Well, I know I have a second with Stacey Abrams, but nobody else is seconding, and it doesn't bode well for the passage. I don't know if I should call her in on that.
Is there a second? Okay, you got a second. Chairman Knox wants to be recognized.
I had a question on the amendment. This looks like we're going to have them reporting frequently to the sheriff if they sleep under. Most folks who do not have a permanent address sleep under one bridge for a while, and then they sleep under another bridge, and then they go to the, in a vacant building or whatever. They're all over the place, and frankly, I don't think what kind of a law we have on the books, they aren't going to do it anyhow. I mean, they're just not going to do it. What do they got to lose? You're going to put them in jail where they have to get 3 meals and they can stay warm and out of the rain and all that sort of stuff. I mean, I'm just wondering whether or not this really fixes the matter or not.
Okay. Any further discussion? Okay, the posture we're in is we have a motion do pass on the bill, and we have a motion that was seconded on the Benfield amendment. Let me ask if there is objection to the Benfield amendment. There is objection. You wish to have a vote, Representative Benfield? Yes. Okay. All right. All in favor? Any further discussion on the Benfield amendment? Hearing none, all in favor of the Benfield amendment, please indicate by raising your right hands. All opposed? The Benfield amendment fails. Any further discussion on the motion? Any further discussion on the motion? Jill?
I just needed to know the posture of the Levitas amendment on page. I didn't know if that was the in writing.
I don't think I recognized him, since we didn't have a motion to technically make the amendment. I'm happy to recognize someone if they would like to do that. Representative Setzler?
Mr. Chairman, I just wanted to speak on behalf of those that oppose the Benfield amendment, just to say I'm certainly sensitive to the concerns. I can say that my objection really is based on the issue that I believe if the state has an interest in establishing addresses for sex offenders who've been released, in some cases early, based on the belief that the court system believes they can be on the streets and have some freedoms instead of being in prison. There's certain responsibilities taken on by the individual to establish an address and establish a level which would be the basis of accountability for communicating with a person, for mail and any other contact. And that for a person's contention that, I'm just going to be on the street, I don't have an address, therefore I can, by virtue of not establishing a residence, can really opt out of the controls and oversight that I think is consistent with this code section is irresponsible on our part. I understand the concerns, but I think if there's a person that chooses to sleep under a bridge that has another individual or advocate or family member or somebody that they could establish an address, I think there's certainly means of doing that. And I think I appreciate the amendment, but I don't think it advances the purpose of the public policy. That said, Mr. Chairman, I do want to ask for the will of the committee. I had contemplated an amendment. I don't know that I've got one that can solve the problem I was seeking to solve. I want to ask the sponsor, is it your opinion that the current language satisfies the need to get that information far enough in advance from the offender about the projected residence, so issues of oversight and visibility of where the sex offender's residence is adequately handled under the current code? I'm just concerned, without specifying, we're kind of running fast and loose.
We want to if you want to put in there, they have obligations to notify the Department of Correctional or whatever themselves within 15 days. We won't object to that.
My concern was, back on page 3, line 6, it talks about 3 business days after the sex offender is placed on probation. That's not 15 days in advance. That's 3 days after probation. So I wouldn't want to get crossways with that by making something that's more stringent. I'd considered even language that says down in section 5, lines 17 and 18, provided the required registration information to the appropriate official before being released from prison, placed on probation, supervised release, or parole, supervised release, or probation. I considered timelines consistent with Code Section 42.1-12, which in essence directs somebody based on the requirements of the government entity that's overseeing them. You've got to let them know what your residencies would need to be. I just would ask members of the committee if there's any discussion on that, Mr. Chairman.
Are you offering an amendment?
I wanted to offer that to the committee to see if there's any discussion before I offer an amendment. I don't want to offer an amendment that the committee's not in the posture to accept.
Okay.
Well, Mr. Chairman, let me do this then. If it's the will of the committee, I'll phrase an amendment, and if we adopt it, we adopt it.
Go ahead. Be daring.
Thank you, Mr. Chairman.
Representative Benfield, follow her lead. Now, if you don't want to offer an amendment, I mean, if you have an amendment, I'd like to go ahead and deal with the amendment. I don't know what the will of the committee will be, but I'm happy to.
Okay.
See.
Mr. Chairman, my amendment would be phrased as follows on page 3, line 17. Consistent with timelines required under Code Section 42-1-12, comma. And then it would read, provide the required registration as it already does. And what that does is it references the Department of Corrections requirements to provide information. It would make the offender's timelines for informing the appropriate official consistent with the appropriate official's mandate to notify other agencies.
Okay, first of all, is there any question about the Setzler amendment? Any question? Is there a second? There is a second. Is there objection to the Setzler amendment? We have objection. You wish a vote, Representative Setzler?
Yes, sir.
All right. All in favor of the Setzler amendment, please indicate by raising your right. I'm sorry, Jill.
I just mentioned, this part of the issue is that 42-1-12 is about 20 pages long, and you just have sections of it here, and the language proposed by Representative Setzler is consistent with the timelines established in 42-1-12. There's all kinds of timelines. There's 72-hour timelines, there's 48-hour timelines, there's 3-day Christmas Day timelines, there's 15-day timelines, and so I'm just putting you on notice that I'm not sure how much more, I think that there might be some confusion caused by adding just consistent with timelines with 42-1-12.
Mr. Chairman.
Representative Setzler.
My intent is, if there's, in 42-1-12, if there's timelines that require the offender themselves to provide information, that's simply reflected here in lines 17 and 18. If there's timelines that are mandated for a government agency to provide information, what this would simply do is require that the offender themselves provide the information to that agency in a way that would allow the agency to make disclosure that they have a duty to make in the timelines in which they have to make it.
Legislative Council is saying is that the amendment as offered is not sufficiently tailored and specific to these many timelines, and that it might be preferable for you to just designate a proposed timeline. Am I accurate? Do you want to do that? Let me let you think a minute. Chairman Knox had a question. I'll come back to you, okay?
I don't know.
Chairman Knox.
Thank you, Mr. Chairman. I don't know if this goes to Legislative Council or the sponsors of the bill, but here's my question. Regardless of whether we have Department of Corrections required to make this report, or if we have the individual required to tell us where they're going to live, they still have 72 hours to tell you that they're going to live someplace else when they get out of the prison, and that's basically what we're talking about here. And if they decide they're going to move somewhere else, they have another timeline. You can't. I just don't think that. I think basically what we're doing here is we're shuffling papers again and making a lot of paperwork for people to send back and forth, because we're not going to be able to keep an eye on this with the bird in the sky on every sex offender in the state of Georgia at every instant that they're out and about in public. It's just not going to happen. I don't care how much paperwork you got or what kind of reporting they're doing or whatever, because I just don't think the mechanics of it get us there. And simply having them say, I'm going to live in Fulton County, and they decide when they get there they're not going to live there. They're going to get back on a bus and go to some other county, and they can do that. I don't think there's anything that prevents them from doing that, as long as they comply with the residency requirements, which says you can't be in so many feet and all that other good stuff. And you have to tell the sheriff of that county in 72 hours, wherever it is, unless we ban them from certain counties, they can go any place they want to.
Representative Setzler.
Thank you, Mr. Chairman. This committee endeavors to write good law. Sometimes we settle for adequate law. What I'm simply trying to do is, to the extent the public policy outlined in Section 4 is meaningful, to the extent we believe that we need to change, we as a state need to change the law to require that the Department of Corrections provides to a county sheriff 15 days in advance certain information. To the extent that's important public policy, our laws need to be consistent in a way that ensures they get that information and it can be provided, or what we're passing in Section 4 is hollow. I think this is an example of where we've got to establish what our public policy intent is first, and when that's clear, and I'm not sure that it is clear, but when that is clear, then we line all the code, and what we vote on is words on a page, but we align those words on a page in a way that's consistent with that public policy intent. And I'm prepared to vote on this bill without making amendments, Mr. Chairman, but I think we'd be passing something that's not consistent.
Okay. Okay. Any further?
Mr. Chairman, I would certainly ask members of the committee if there's a way to make this consistent, then please suggest that. If by adopting the amendment that I've offered simply complicates things and makes things worse, I'll withdraw the amendment and we can vote on the bill as it is. But I'm simply trying to make this language consistent. And if Legislative Council suggests I'm creating more problems than I'm solving, I'll withdraw the amendment.
I'm not saying that. I'm just saying that, I mean, for example, in that sentence, required registration information, that's a defined term. Appropriate official, that's a defined term. And then within 42-1-12, there's all kinds of timelines. And then in your language is consistent with 42-1-12, and this is direction for the sexual offender. I think that if your goal is that the sexual offender needs to be able to comply, so that Department of Corrections can comply with the 15-day issue, that you need to say, provide the required registration information to the appropriate official at least 15 days prior to being released from prison.
Would it be more appropriate to put it up in Section 4, line 7, even though it's directing the Department of Corrections to say the information shall be provided by the sexual offender and forwarded to the sheriff's office?
The issue is this: the way that 42-1-12 is divided, each subsection has like, you do this. And right. C is what the Department of Corrections does.
Okay.
F is what the offender does.
Okay.
H is what the sheriff does. So that's how when we rewrote this a few years ago, we divided it up so that, because it used to be all mixed together, who did what, when, and where.
Okay.
So, but it's up to you.
One last question, I hope. Looking up at the timeline we establish with respect to placement on probation, there's not a 15-day requirement for placement on probation. It's 3 business days after placement on probation. I would be interested in reflecting in Section F, 15 days prior to placement on probation or release from prison, and 3 business days after being placed on probation, I think.
Well, we're not going to know whether the person's going to receive a probated sentence or one. There's no way to know that in advance.
Mm-hmm. Right. That's why I don't think the 15-day language makes sense.
If I may, Mr. Chairman. Yes. And that's the reason that 3 days was added. But would it not accomplish, may I, Mr. Chairman? Sure. Would it not accomplish your intent to just use the specific site as opposed to the 42-112?
Okay.
To use paragraph 3. That language in paragraph 3 is what you're trying to capture.
Yes.
In the next section. Couldn't you just use
consistent with 42-1-12, subparagraph 3.
The only problem with that is that sentence, line 17 and 18, is provide required information to the appropriate official. I don't know, and I have to look at 42-1-12 specifically to know that
that may be
where
broader.
you live is the only thing that's the time catch, and I'm afraid to do that on the fly.
Mr. Chairman, I want to withdraw the amendment, please.
All right. Any further discussion? Any further discussion? We did have a motion due pass, didn't we? Okay. All in favor of the motion to give Senate Bill 249 a due pass recommendation by committee sub, please indicate by raising your right hands. All opposed? Motion has been adopted, and it will go on to the Rules Committee with a favorable recommendation. Thank you very much. Two quick announcements. The Burden Subcommittee will meet momentarily here in this room. Two bills are on that agenda, and he is in another meeting right now upstairs, but expects to be back momentarily. This meeting will be adjourned. Got bits and forks, dude. You told me.